Richard Novak, Michael Burt, and Stacy Visser for Mr. Robinson, who's present in the courtroom, Your Honor.
Good afternoon. Mr. Robinson, good afternoon. And also for the record, the court recognizes the presence of victim representative, Ms. Erica Kirk. Good afternoon. First, with respect to courtroom protocol.
Welcome to the stream. Sorry it crashed, guys. I had to start it all over. Hopefully you're back with us. This is live right now. This is day 3. So we are watching the live stream from the courtroom. Sorry about that, about the stream crashing. Nothing I can do about it, though.
Such measures may include the use of screen protections on electronic devices and care to avoid inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. And as you note, the microphones on your tables are turned off. So please come to the lectern.
This is Kelvia, by the way.
You're addressing the
Kelvia
court.
Campbell. She goes by at Conservative KFC.
Camera and
she is an ex-TPUSA representative that was fired during the big wave of mass firings. We'll talk more about that during the break. But she's joining me as my guest co-host today because Convict to Conservative had to step away, had something come up last minute. So welcome her to the stream, everybody, and be sure to follow her.
John Wilson, KSL Television.
Tess Crowley, Deseret News.
Good afternoon.
Here to get justice for Charlie.
For today's hearing.
Video recording and streaming of the proceedings.
I'm the pool still photographer.
All right. And have you both reviewed the court standing decorum order?
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
This is new.
Do you anticipate any difficulties complying
Why are
with
they
the order?
pulling up the damn photographers?
Thank you both for your
That's
cooperation.
weird. They never did that.
As we begin this afternoon, the court wishes to acknowledge the importance of safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests,
Erica there?
All persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom
or
on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone
show her outfit for the day
may be addressed by the court. For those individuals who are authorized to have a cell phone, please place your device on silent at this time so that these proceedings may continue without interruption. The court also expects that every person in attendance will be treated with the dignity and respect to which they are entitled to. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during their hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause. And with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately so each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. An overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First, turning to the state, and if you wouldn't mind coming forward, Mr. Grunander.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Falmina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
Good afternoon, Your Honor.
Good afternoon.
Michael Bird for Mr. Robinson. Judge, we have two remaining witnesses, Miss Oliver from the ATF and Miss Carner also from the ATF.
All right, and to both parties, thank you, I appreciate that. Do both parties anticipate any issues concluding their case? Obviously, there's variables, cross-examination, and kind of the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.?
Not from the state, Judge. Just want to highlight one issue for the court because it may be that the court wants to do some time management. The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions, not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state so the state could raise any concerns about the accuracy of the transcript. That's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So to use court time for the court to look at the proposed redactions may be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday. But it's going to come up today. And so the question will be, when does the court want to engage in the process of reviewing a 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up. Mr. Grunander, do you wish to be heard?
Yes, Judge.
How is that a heads up if he said
No,
it's
the
going
state
to
has
come up
received
today?
the proposed
You really didn't
redactions,
give
and we
them
are
any
prepared
heads
to
up.
address them when that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
All right, well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you. All right, does either party require the benefit of the record before we begin? To the state.
Ryan McBride for the state, Your Honor. Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence, except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles really at this stage. One is a gatekeeper role on admissibility, and the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding. And the court, Rule 104A means the court can consider evidence even though its admissibility has not yet been determined in its gatekeeper role. And then after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant at a preliminary hearing where foundational evidence is reliable hearsay under 1102B3. Even at trial, State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers, when acting in its fact-finding role, only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper, even though the judge as a gatekeeper considers potentially inadmissible evidence. It also means that the court doesn't have to distinguish which hat it's wearing as we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the presence of the jury. Under the rules, there's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law and that's conforms with 104B. That's our intention unless the court or counsel moves to close, the hearing. So in summary, the court can and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
Well, I'll hear from defense if you want to be heard on that issue. I see you. Okay.
Briefly, Your Honor, I'm sorry, I have 2 microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right. All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record, I ask 3 steps. Admissibility, to admit it, to be published in the courtroom and then to be published on that screen. And I'm going to have the screen adjusted slightly because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those three issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right, anything further?
No, Your Honor.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness. Yes, I mean, I want the press to be able to see it too, but when there's a bit of a distortion when it's at that particular angle. So while the parties are moving forward, go ahead and adjust it. And let's put a sample image of something that has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. And I don't know if we need to take a break to make sure that's working.
Is it not projecting on the monitors? Okay. Technology is challenging us again. Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming? All right, all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind turning off your monitor and then turning it back on. And if I could borrow somebody to do that to the witness monitor as well, so we all get them in sync. Thank you, sir. I appreciate that. And for the lectrum as well, let's just see if we can get that up because that could cause a delay. I just want to knock this out first. Yes.
He seems super agitated.
Where would that TV go?
Yeah, the judge is always seems to be high strung and agitated.
I know, like he's like, hurry up and get this over with.
Let's do that. I just want to make it easy. That way that TV can be more flat and it's not a distorted view.
He just wants to hurry up and get Tyler convicted and be done with it, you know?
Transparency needs to be viewable, not just there in concept.
Yeah, he looks like a Mitt Romney fan, like I told you.
How are the monitors looking?
Big time.
Nothing?
Looks just like him, really.
I see. Could I have someone with your laptop plug in so we can test, so we can check if it's receiving the data or the information from your laptop to allow us to project? That may be the issue.
Mr. Ellis is plugged in.
All right. Let's take a look here. I appreciate the party's patience, especially after I just said we're at the halfway point.
We're getting a thumbs up.
All right, so it's displaying for defense, for prosecution.
Working on it right now, Judge. Yes.
All right, and on the screen monitor here, it looks like something came up. All right, we'll just hope that the monitor for the witness works as well. All right, so we're ready to go. Just bring it in and go ahead and we'll get started. And how much time is needed for that? Well, let's go ahead and proceed. And then when we take a break, then we can do that. But for now, the media, if you can see that TV, if you have any problems, please let me know. And we're going to bring in that second TV. We just want to get the train on the track here. All right, Ms. Hunt.
The state calls Agent Brian Davis.
Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in
This
the case
guy,
not
I
pending
really
before
want to
the
hear
court will
his
be the truth, the
testimony
whole
because
truth,
this
and
guy's
nothing but the
corrupt
truth,
as
so
shit.
help you God.
All right.
Yeah, it'll be
Agent, if you wouldn't
interesting.
mind having a seat. To your left is a water bottle. And after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice and we have a good record. All right, Ms. Hunt, your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
Total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with the Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did.
What year did you complete that?
1999.
You know, something else I noticed is a lot of these cops
Is that a
were
type of
transferred
certification that you
after
hold?
the assassination.
Yeah, it's a
They were
statewide
transferred to
certification
that
that any
American
peace officer in
Police
the state of Utah,
Department,
local,
which is the
state,
same
county,
police department,
go
which
through
is
to
in
become
hot
a
water for the
certified
bricks and
police
minifigs
officer.
Lego.
Has that
piece that's blown
certification
up
lapsed
everywhere.
or been any gaps in that time since you received it in 1999?
Yeah,
They're all
same with
corrupt,
medical
so that
staff
makes
at the
sense.
hospital.
Since then.
I want to talk
Yeah.
about
Remember,
a bit about
they had
your
new, they had
training
new medical
experience
staff
within
too.
law enforcement. What roles have you had
Yeah,
at
very
SBI?
I began as a alcohol enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, Officer Involved Critical Incident teams around the state of Utah and within SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of cases. I work anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white collar crime, fraud. I was also on a task force with a FBI public corruptions task force as well.
Was that all on the job training or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a FARO certified. It's a 3D FARO scan of crime scenes.
What's a FARO scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on been certified as a forensic interview and the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI.
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the case as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have two case agents on a case?
It can be especially on a large case, yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably
They said it was you.
several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Orem Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about.
That's a dumb question. Everybody knows what that means.
So as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elsholz requesting that I travel to St. George.
Who is Sergeant Elsholz? What agency is Sergeant Elsholz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Just like Baron Coleman
yes,
said,
so we traveled to the Salt Lake City Airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was
shout out to you, Paramount
Sergeant
Tactical.
Elsholz.
Lisa knows nothing.
Was Agent
Paramount
Folger with
Tactical,
FBI, Agent
Lisa knows
Anderson with
nothing.
FBI,
You guys
Ryan
just
McBride
got
and
proven
myself,
wrong right there.
and the two pilots.
And who is Ryan McBride?
Yep.
With the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI, as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents with an SBI assigned to the Southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
Did you mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device. And so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, yeah, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. Or I guess, how did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes. Myself and Agent Folger. Did I
You
miss?
better have been.
Speak earlier. Myself and Agent Folger interviewed the mother.
If he's
All right,
testifying,
let's
he
make
better
sure
have
the
been.
record's clear on that. So Agent Folger, what agency is he with?
With FBI.
Exactly.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear.
But
Who
he didn't
interviewed
say that
Tyler's
his
father?
parents
Yeah,
turned him
I
in.
misspoke. It was Agent Holgreen, Agent Cox that met with his father.
No, Tyler
then
turned
who
himself
spoke
in.
with
His parent, the
Mitchell?
whole thing about
Agent
they
Terry,
noticed the
Agent
rifle, that's a complete
Smith.
lie. His parents didn't notice the rifle because they never showed the rifle on live TV or
Down
the media.
in
That was
St. George, Washington
a
County
stock
Sheriff's
photo
Office.
of a
Was
different
Mr.
rifle. That
Robinson
wasn't even
detained
the
at that
rifle
time?
Tyler had.
Yes, he was.
Was he formally arrested at that time?
Yeah, following after all the interviews were completed, when we talked to everybody, he was formally arrested at that time.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, could I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
Yeah, she's not doing great, in my opinion.
That may happen a couple more times as we go through exhibits because of agreements and disagreements that we have.
Thank you for the heads up.
You also hear him whisper something
At
about,
Washington
you
County
do the
Sheriff's
you're not doing the
Office,
redacted
where you
version
initially
or something.
observed Mr. Robinson. You stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview in which Mr. Robinson was seated and waiting.
State moves to admit Exhibit
Why
15.
can't we see it? Exactly, I
Ms.
want to
Hunt,
see it.
And
Exactly.
the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, I guess, redaction of the video. And I would ask to publish it both to the courtroom
Gosh,
and
is she an intern?
to the media.
Why is she?
you know that?
Yeah, for real. She's horrible, man. Why would they put her?
Yes.
This is the biggest trial
Yes, Your
in
Honor,
the
Ms. Hunt
world.
is
Why would
correct.
they put
The
her
state
on
had
this?
originally proposed
Where's that
a
blonde woman that
longer-
has been there?
image with
Yeah, I don't
audio.
see her
We've
today. I
agreed
don't
to a
know.
Shorter image with.
He's
audio.
good.
And so
I noticed that right off that she wasn't there.
So the defense wants
we're
to
fine
post
with
it
all three
without
steps
audio.
As to this exhibit.
All right, does the state wish
That's
to
not right.
review this to make sure that what's queued up comports with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
You're paralegal. You act like you're a paralegal yourself, lady.
I was getting ready to say, that's an assistant to an assistant.
For real.
The
This chick is
paralegals
horrible.
probably put more. Yeah, she's terrible. I want the blonde lady back.
Yeah.
It's has no audio, so we would like to admit and publish it at this time.
All right, State's Exhibit 15 is admitted pursuant
Why are we
to,
getting no audio? This is such
discussion
bull crap,
and may be
man.
published in the courtroom and may be recorded or transmitted electronically. Just
And Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the last couple of days. I assume that we don't need to start over with that today.
thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection is overruled, and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right. All right, State's Exhibit 15 may be played.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching
Can
it
we
on
see
video,
his
what
face?
is he wearing at this time?
He's working a dark colored baseball cap with a has like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes. I believe they're Converse style tennis shoes.
Yeah, it does look like the same color
Thank you.
clothes as in the video.
Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA, and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famawina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning. And then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
That's a real guy.
Too into it
He's
right
the
now.
one
We'll
that's
cover
really
this with
guilty.
Sergeant Palomina, but did you receive information from
how are they
officers involved in those
justifying him
execution
not
of those
being
warrants about what if anything
examined?
has been found?
Yes, I did.
You tell me, man. It's ridiculous.
All right,
The
turning to another
hearsay is
area,
bullshit. That
as
should
part of
not
this
be allowed.
investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
Was Ryan McBride, Chad Grunander, Kimberly Derfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Derfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement?
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at, it was the St. George, well, it was the St. George Court office, courthouse there. They met and discussed briefly, just kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. Sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge. That any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you what's been marked for identification as State's Exhibit 14.1. Let me know when you see that on your screen.
Okay, I see him.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt for the same purpose?
All right.
And how do you know that?
I've reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So.
And Kimberly, if I can have you slowly scroll down.
He doesn't mention local law enforcement that much, does he?
Sorry, Judge, if I can just have a moment.
No, the SBI are the ones that really took the lead. Even early on, local law enforcement was told by the FBI, actually, do not interview any of the witnesses or anything. They were actually given stand down orders, which is crazy to me.
Yeah, because local law enforcement should have gathered everything they should have on 9/10 and then relayed all of that when they arrived. When FBI, ATF, when all of them arrived, they should have had all that ready to relay to them.
Exactly. It's wild to me that because that's
I
another
apologize,
thing
Your
that
Honor.
was
I
very weird at the
misspoke.
time
It's
is the
not
FBI
14.1. It's just
that the
Exhibit
FBI
14.
were at the scene
So
so
if we can
quickly. Within
place
like an
that again
hour
on the
of the
screen
shooting,
for
the
the
FBI
witness
were
only.
already on the scene, as if they knew it was coming.
Yes.
Yeah.
And sorry, we had been scrolling through
probably
that.
scheduled.
Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission, states Exhibit 14 into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is
Yeah,
is
it
the
might have been
unredacted
minutes,
version.
actually. I know it's really,
So I
really
wanna review
fast.
it
It was
before
definitely
I-
within that
I-
first hour.
Make that decision.
Yep.
By the way, I'm not monetized on YouTube. If you guys want to contribute to the stream, you can scan the QR code at the bottom of the screen there for the Buy Me a Coffee on the left-hand side of the bottom of the screen. Leave a comment, and we will read your comment out live on air during the breaks as a super chat. So if you want to have your comment read on stream, just scan the QR code down the screen there and leave a comment. Yeah, if you got the clip of that, absolutely, please send it to me. You can either DM it to me or send it to my email, projectconstitutionvideos@gmail.com. Thank you.
What video is she referring to?
Where Cash Patel, I guess, is saying that they were at the scene within minutes, or somebody from the FBI is saying that they got to the scene within minutes.
Cash Patel should have gone since Charlie basically got him in Trump's cabinet.
Oh, he did, but he wasn't there within minutes, though. He was in Washington. He had to fly there.
Yeah.
Although when he got
had
there,
a chance to review State's Exhibit 14 and noting the standing objections by defense concerning 1102's court accepts into evidence State's Exhibit 14.
We'll talk about that later.
To the parties is not published.
Thank you, Judge. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about?
Yeah, that's important. I want to know what that is about. Because they pretended like that was not important at all.
What roof was that bullet found on?
I believe it was it was found on the computer science building on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent
Is
was
there
that?
pictures?
It was Agent Ben Schneider with SBI.
Wait a minute, collected it. They said they did not
Are
collect
you aware
it.
of where,
Yesterday they
of where
said
the
they did
computer
not
science
collect
building
it.
is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LoSI building is, it's a building directly kind of south and east of there from the LoSI.
Southeast from the LoSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have
So
been
where
from
was
that
the
roof
bullet
of the
in
computer
relation
science
to the
building, to
sniper
your knowledge, would there
plan?
have been a line of sight to Mr. Kirk's tent?
No, not according to the agent.
They found
Agent
it
Ben
on
Schneider, there
on
was
a
not a
roof,
line of
but
sight from there to where the tent was, where Mr. Kirk was.
hold on.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a 223 caliber.
What is a live round?
223. Holy
It's
shit.
it's a round that had not been fired. So it still had the projectile, and it was a fully functional bullet with, ammunition with the bullet.
Did you learn if this 223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact, still had the primer had not been, it was not dented up and fired. It still had the bullet projectile in the end, still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. You've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
DNA swab
I don't
they're
recall
talking
if it was
about.
there or later at his residence.
But ultimately, a
That's
buccal
very
swab was
important.
obtained from Mr. Twiggs.
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So they did take
So it was
Twiggs'
during that
phone from him.
interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
Well, they didn't.
You
Okay, so they
mentioned
didn't confiscate it
second
then.
interview of Mr. Twiggs?
There was a second interview, yes.
When did that take
He
place?
just looked through it. It
April
sounds like
20th
he let
of
him
this
look
year.
through it.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well, now it's Lieutenant L. Schulz, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before
So when do we
Mr.
get to
Twiggs'
hear the
interview on April
recordings?
20th, 2026. Well,
Exactly.
first let me ask you this.
It's
Are you aware of
probably
what use
inadmissible.
immunity means?
Yes.
Yeah.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews
So the feds
were
gave him
recorded.
limited immunity
Have you reviewed those
also.
recordings?
Yes, I
That's
have.
interesting.
Do
Based
they
off of
fairly and
what?
accurately depict those interviews?
Yes, they do.
Yeah, I would like to know because he's more guilty than Robinson.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
That's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview?
I mean, they're
on
almost
April
treating
20th,
them like
2026?
spouses.
Yes, it was.
You know how spouses can't
By whom?
testify against
By
the other?
Brian McBride with the Utah County Attorney's Office.
Yeah,
And again, you were
it's
present for that
definitely
interview?
Strange
I
how
was.
they're handling
Did
it.
Mr. Twiggs say that he understood that admonition?
He did. Yep. Yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first. And if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not, I did mention that defense prepared a transcript of this recorded interview, how the state intended to present it and how we have given it in discovery to defense is it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just, block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it, that they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds. Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out, and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between
let us hear the video.
Evidence
we want to hear
disregard
it. I think we deserve to hear
at a preliminary
Lance
hearing
Twiggs'
or even
testimony
at a bench
in
trial.
full.
State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans, 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is to quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate.
I don't know why they waited so late if they wanted things
objectionable
redacted.
Statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line.
Thanks so much.
And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into evidence states exhibit 16.
Yes.
And as it relates to publication, what is your request?
So, Judge, we believe, and I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits. So we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So your request
we
is
deserve
that
to hear
the video
this
not be projected and captured by the video camera, but the video and audio is played in the courtroom and the audio is able to be transmitted, just not the video via the camera. Is that my understanding?
Correct. That's the state's position.
All right. And in regards to this exhibit, is in the, as state's exhibit
that's not
16, right. Is there any portion of that recorded statement that occurred before the 1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, turning to the defense, Mr. Novak.
Thank you. So I'm going to address first,
It's some.
Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry. The court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript, excuse me, it's only a 20-page transcript. We have given the state a transcript we prepared ahead of time so that the state could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the state doesn't have any dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 11:02 interview. There's no surprise here. There's been all of Monday evening, all of Tuesday, this morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made. This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court, and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 11:02. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single
So they were leading the witness.
Mr. Twiggs is just an affirmation of what Mr. McBride says.
They were
but the vast
prompting him
majority-
probably.
Oh, that's crazy.
There are also portions of this.
They were telling him what to say,
where Mr.
basically.
McBride is basically testifying
No wonder they
as
don't
to
want to
what
show it.
other exhibits that this court will see say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and a group chat. I'm just going to distinguish between the two.
And these guys are so corrupt.
And so this 11:02 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 11:02, those portions of the 11:02 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court by the state. There are also portions of this 1102 which are not relevant and really implicate Mr. Twiggs' privacy rights. And I am not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, well, I don't want to speculate. But it's not relevant. There are portions of it which are not relevant, and there are portions of it which I think, especially to be broadcast, implicate other privacy interests. So I'm not trying to create complications, and I'm definitely not trying to take the state by surprise, because I went to great lengths to provide the state with a transcript, with a proposed redacted transcript. And in fact, today we prepared to make it easier on the state and actually on Your Honor. Instead of having redactions with big black sections, we highlighted them instead. So if the court wants to look at our proposed redactions, the court can do that without having to compare two documents. The other thing I want to say is that if the court did order ultimately that portions of it would be broadcast in any way, in the courtroom, outside the courtroom, we're not trying to change the state's exhibit from a video with audio to a transcript. The transcript is really being used as a tool to address the inadmissible portions of the video, because there's no way to communicate to the court efficiently which portions of a video we think are not admissible. It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it'll probably take a couple hours at the most. So maybe that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing by Friday afternoon. So I've gone beyond the procedural issues. I've addressed that we think portions of it are not admissible. There's no surprise. We've followed exactly what the court has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing, and I don't want to hear objections about it until we're in the middle of the hearing. The litigation over whether Section 1102 is constitutional under Mr. Robinson's federal due process rights and the other rights that were addressed, that litigation does not mean that we should have brought to the court proposed redactions to an exhibit in a hearing which hasn't started yet, in a hearing in which the state hadn't until 20 minutes ago even proffered an exhibit. So I understand that the state wants to avoid the substance by trying to short circuit this with a procedural argument. And Ms. Hunt is a very excellent advocate for her client. But the reason why the state is going to the procedural issue is because the state, well, because the exhibit contains significant content that is not admissible even in a preliminary hearing. So I'm going to stop now, but I do want to go back and say that if the court concluded that only Your Honor was going to review this exhibit and the Archuleta rule would be extended to this exhibit, including that it's not going to be broadcast, then I think that we have a different path toward the efficient resolution of this issue.
All right.
Does that make sense, Your Honor?
I believe I understand what you're saying. So let me respond to you before I go to Ms. Hunt. So going to your first point in regards to what this court's position in not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated before anything is moved into evidence. Typically, motions in limine are used by either side on anticipated exhibits or that may come into court, and that allows pre-litigation. So I want to clarify that the court statement, like I'm not looking at the exhibits, is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. what exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant. We could do it line by line or page by page. I know we have had hearings in this matter where the court has wanted to look at transcripts line by line, word by word.
Yep.
We're prepared to do that, but I'm going to give the court categories.
Thank you.
Without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video.
How does that
as to what other exhibits say? And Mr. Twiggs is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So I apologize. I don't mean to interrupt you.
No,
I just want to categorize it and put it in a box. So what is the what objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here,
sure,
because there are two exhibits that I'm very confident are coming. There are portions which are not relevant. There are portions which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today, in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Thank you.
And I heard exactly what the court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had said to us, I'm returning the exhibits, but if any party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that it's probably for counsel a suggestion about how future hearings where there are many or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins, so that the court knows these exhibits, there are no disputes, these exhibits, there are disputes, these are the disputes, and we don't have to waste courtroom time bringing the court up to speed on what those concerns are. It can all be briefed ahead of time. And we're happy to do that.
Thank you. Well, going to the last point, let me be clear on the record that I don't intend to interfere with the duties of either party. It is not my job to say, well, here's what you should do, here's what you shouldn't do. I'm independent. I'm not team prosecution, team defense. And so
bullshit.
I will not dictate how you run your case.
He's been against the defense
Obviously,
the entire time.
Goes against certain rules, constitutional rights, statutes.
And yes, you are the
case
person
law,
that approves
I will
this.
weigh in, but I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state.
Fine,
Mr.
let's
McBride,
go through
here's
it
what
line by line
I think
then.
you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do. I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client to the state, what is in the best interest of your client. I staying clear of that, but I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management. And now I think we're moving pretty far away from the admissibility of this 1102 statement, and we could have a conversation later if the court wants to. It's up to the court about case management issues. But as I said before, if I say anything else, I'm going to be repeating myself. So I'm just going to stop.
All right. Thank you, Mr. Novak. Appreciate your thoughts. Ms. Hunt.
Yes, thank you, Judge. And as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, yes, to be fair, he did send me a transcript with proposed redactions Monday, I believe at about 4 p.m. It was not accompanied by any objections that he actually had. So we had to compare the transcripts and to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be. And obviously he's now given categories, but I think we're now at the point where the court needs to exercise its ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing. And then probably, I don't know, I'm assuming the media attorneys will want to weigh into that, because I do want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing, and hear from the media or any other parties that need to weigh in on that.
All right. Anything further from the parties as it relates to that?
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're not for the public in real time.
I gotta run out to my car real quick. I think I left my phone in the car. I'll be right back.
It is very standard that sidebar proceedings where information is only to be exchanged between counsel for the parties and the court are conducted at sidebar so that witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings conclude or the court conducts some closure analysis on a topic by topic basis. So that's what sidebars are about, whether it's done in a closed hearing or in an open hearing through whisper. The public, potential witnesses, jurors, potential jurors don't get to hear what the court decides needs to be addressed in a manner which protects the parties' rights.
All right.
Your Honor, if I may, Michael Judd on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. Can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors.
I like this guy. This guy's been making good arguments the whole time.
Has to take
He's the attorney for all of us, for the media.
I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here.
He's definitely more aggressive than
position
the other
likely
ones.
be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview that is at issue here is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing. There may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video. The public hasn't seen this video. It seems to me that this appears to likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta, at least part of its reasoning is based on something very different than putting something on a screen. In Archuleta, there was a request to say, hey, is there a murder weapon? Are there crime scene photos? Can we come handle those, right? Can we look at them? Can we turn them over in our hands? And part of the reasoning in Archuleta was we're worried about that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks. Because this is so important. So this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is that it should be shown on the screen and that the public should be allowed to see it as well.
Absolutely.
To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then something like the state has provided, which is you would put it, you allow the audio to play. If there is some sort of, it sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure or keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible. And if there is any sort of narrowing of the public's right of access here, that it be done only in the narrowest way possible, and that it be based only upon recognized interests. And finally, I would say, Your Honor, to the extent that I hear any sort of real counter interest at all, it continues to be a fair trial interest. Take that important. We take that, we recognize that its importance, we take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire, we can handle those counter interests. And on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you. Any further comment by any of the parties? All right, Mr. Novak.
Only that I want to make an additional assertion about why the court should handle this exhibit pursuant to Archuleta. But I want to make that argument a sidebar because the whole point is to protect my client's right to a fair trial. And by making part of this argument in open court, it's a self-defeating exercise. So when the court resolves whether it will hear from us at sidebar, we're prepared to do that.
All right. The issue is sidebar is public because the transcript's open. So it's just because the parties request sidebar and the court invokes the white noise, that doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing. So
then we would like to have a very brief closed hearing to lodge another objection about the publication of this
There is no
of any
closed
portion
hearing.
of this exhibit.
I'm getting real sick and
certain
tired of the
portions of this
defense trying to
exhibit
hide
beyond
the
Your
public's
Honor's
access
eyes.
from seeing all the damn
That's what I'm
evidence.
saying.
Thank you. All right, right now what we're going to go ahead and do, and what I want to do is I want to look at the redactions that you're proposing and take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially for future exhibits. So that's going to give us our 15 minutes. I want to review that so I can be brought up to speed because the transcript, from what I understand, is just a transcript with suggestions of what defense wants to redact. Is that correct?
That's correct, Your Honor. And so what I would suggest, well, if this works for the court, is we will email to the court staff with something we've already given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to be presented as evidence. We can get there if the court concludes there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the proposed defense redactions, and Mr. Ellis can make sure that your court staff receive that, and it can either be emailed to you or printed out, whatever works.
Any objections, Ms. Hunt, from the court reviewing the proposed redactions in order to bring the court up to speed at whatever argument the court may entertain?
No, Judge, but I want to clarify for the record and for myself, is the court ruling on my procedural objections, and I want to reserve the right to make my substantive arguments using what's actually in the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break and then we're going to come back on the record. But on the break, I'm trying to maximize the time. And that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting? I just want to bring myself up to speed. So on the next step, when I make my ruling, the court is ready to go.
Okay,
and maximizing the time, because we also want to put up a monitor. So there's like 3 things we can accomplish in the space of 15
Fair enough.
minutes.
The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, well, let's go a little bit longer. Just I want to make sure everything is in place. Let's come back at 3 o'clock and we'll proceed from there. Court is in a brief recess.
All right.
Oh, I think you're on mute.
Sorry. Yeah, I was muted.
No, you're good.
Okay, so hold on 1 second. Let me pause it. Not pause it, but mute it. Ooh, oh crap. I didn't mean to do that. Hold on.
Why do I feel like
messed everything up? Why do you feel
one
like
of those
what?
days? Apparently in the courtroom's having technical issues too.
Oh yeah, yep. I'm over here scuffing it. I'm a boomer. Well, not really, but I feel like a boomer.
I feel you on that.
Okay, now let me hold on. Now let's come on, get out of the way. Stop, damn it. Urgh. Come on. Oop, no, I don't want to do that. Why is it not really not going to let me do that? Okay, hold on. I have to do it this way, I guess. StreamYard. Present. Share screen. Okay, now we got to go jack it up to big size, and now I want to go to mute site. That's what I want. I want to mute it. That way it's not blaring in my ear while I'm talking. Okay. Now we're cooking with gas. There we go. Anyway, and by
What
the
are you
way,
thinking so far?
we have Billy Webb. Hopefully, if you guys hopefully are familiar with Billy Webb. But if you aren't, be sure to go follow her. She goes by @Billy Webb on X, and she has a new YouTube channel as well. Her new YouTube channel is, give me 1 second. I want to make sure I share that for her as well. Now Noticing. So this is her YouTube channel, @Now Noticing. Put that in the chat. All right, that is her YouTube channel. Make sure you guys are following her on YouTube as well as on X. And again, on X, she is @Billy Webb and with 3 B's. So it's Billy Webb, BBB. And it's BILLIE, obviously, not BILY. So it's BILLIE. Here, matter of fact, let me put it just to be safe. Just so you guys don't screw it up. Billy, hold on. Copy. Post this in the chat for you guys as well. All right. There you go. @Billy Webb on X. That's her username on X. Be sure to follow her. She's a great independent journalist. She is one half of the former Brandy and Billy show. If you guys are familiar with the Brandy and Billy show, I know they split up now and they kind of went their own ways. But she's excellent journalist. She is at the courthouse today. She's going to be giving us live updates from the courthouse. What she told me is luckily she was able to get in. She's tried the last 3 days to get in, but they're only letting 14 people in, and people have been camping out there all night to get in there. So it's been hard for her she hasn't been able to get in the last 2 days. But she was able to get in today. So she's in the courtroom today. She's taking notes, and that's another thing. They won't let her have any electronics or anything in there. So she has no way to contact us while court is in session. But at the end of the hearing, she's going to come out. She's going to come on the stream with us, and she's going to give us an update of everything that we missed that the cameras did not pick up. Like what Erica Kirk is saying, doing, what Tyler Robinson's family's doing, saying. Same thing with Charlie's parents if they're there. Yeah, so we're going to get updates from her at the end of the stream. So definitely go follow her. And yeah, and also now that we're on a break also. So again, this is my lovely co-host right here, Kelvia Campbell. She goes by @ConservativeKFC on X. Be sure to follow her as well. She is a former Turning Point Action employee. She was fired. She's the only Turning Point Action employee that was fired in that mass wave of firings, not that long ago, when they thought people were leaking a can of Sowens. So I've interviewed her a couple times on my show. She's been on. Great person. The other guy that was with us, Convict to Conservative, he had something come up with his family today last minute, so he wasn't able to do it. So she was gracious enough to fill in for us. So she is here with us today. So everybody be sure to follow her. Her and I actually have been working together too, putting got some stuff coming out pretty soon that you guys are going to like. So keep an eye out for that.
Yep, stay tuned. Stay
Definitely.
tuned. We're going to have a lot of updates.
Oh yeah, oh yeah. They're gonna hate us for sure.
Yep,
Okay,
in the
so
coming
did the
weeks.
Venmo go? Yep, absolutely. So did the Venmo go through yesterday? Yes, it did. Thank you very much. I appreciate that. Well, I got one Venmo. I don't know if it was from you. I got one Venmo. I think it was like $10, I think. So if that was you, hold on. It was from Giuliano, somebody Giuliano. So if that's you, Giuliano, I don't want to say the last name because I don't want to dox you or whatever, but Giuliano is the one I saw a Venmo yesterday. So thank you very much if that's you. I appreciate it. And again, like I said, we're not monetized. So if you want to donate, let me take that off the screen real quick. Okay, if you want to donate, you can scan the barcode in the bottom left corner of the screen. That's the Buy Me a Coffee link, just like Coach Colin does with the Buy Me a Coffees. So you can scan the QR code. It'll prompt you to our Buy Me a Coffee link. You can, donate at whatever amount you want, and then it'll let you leave a comment. And you can leave any size comment. It's actually better than Super Chat because with Super Chat, you only get a certain amount of characters per amount. So unless you want to donate like $100, you're limited to a very short message. But with the Buy Me a Coffee, you can donate any amount and leave pretty much any size message you want within reason, and we will read it out as a Super Chat on break. So if you want to do that, we would appreciate it because these streams, it's definitely grueling to do all these long streams. Today's a little bit shorter day since it's only like a half day, but like yesterday was 10.5 hours long, guys. And we're not getting paid to do this. So, if you guys want to throw us a couple bucks for that, definitely would be appreciative. And
yeah, thank you for those who did, who were supporting us.
Yeah, definitely. Absolutely. And let's see, what else do we have here? We have somebody said followed.
That's what I asked.
That. Somebody said, did the grieving widow show up? I did not see her, but the judge did say good morning. He noted that she's in the courtroom and he said good morning to her today. So I guess she is there. We'll find out for sure when we talk to Billy Webb later today. But yes, I do believe she is there. Okay, hold on. She just texted me actually. She said, ran outside for the 20-minute break. There was a bald guy that I recognized that kept glaring at us. He was sitting next to Jack Peak. Jack Peak, maybe Jack Vasovic. I don't know, maybe. I'm using voice text. If any, okay, she's using voice text, so that's why. So Jack Vasovic, and it came out Peak. Okay, so if anything is spelled wrong, it ended up being. Okay, it ended up being Graham Allen, and I was like, why does this bald guy that I recognize keep glaring over at us like viciously? Hold on. You want to come on the stream for a couple minutes during the break? Question mark. Also, Erica Kirk is there today, right? Because we didn't see her enter, but the judge did say good morning to her, so we just want to be sure whether she's actually there or not. All right, let's see what she says. Let me send her the link one more time in case she does want to pop on here with us. 1 second. Copy. Link.
Hey, Project, I'll be right back.
Okay, yeah, you're fine.
Yeah, give me just a second.
Yeah, you're good. Oops, I hit the wrong button. Don't you hate that when you go to copy and paste something and you accidentally hit you went to hit paste and you accidentally hit copy. So when you hit copy, it clears out the thing that you pasted, that you had already copied. So then you got to go back and start over and recopy it. I hate that. Okay, so there you go. All right, cool. Anyway, so anyway, what I was saying is, I think that while we're waiting, like I said, I don't know if she's going to have, it's only a 20-minute break, so I don't think she's actually, I don't think she's going to have time because they said they're coming back on at 3 o'clock, which would be 6 minutes away. So I don't think she's going to have time right now. But after the show, she'll definitely come on after the show. But so what I was saying is, so it sounds like this testimony, the grieving widow, I believe, did show up. Hold on. So come on now. Come on. Oh man. Why is this acting stupid? Okay, so Lance Twiggs' testimony. This is basically the only evidence that the state has against Tyler Robinson. That's it. Because we saw yesterday the video footage they have, supposedly. We saw all the video footage. They don't have him taking a shot, and the only video footage that they have is so blurry that you can't make out for sure who it is at all. I mean, there is not one single frame of that video they showed us yesterday where you can definitively say that for sure is not Lance Twiggs. That for sure is Tyler Robinson. Not a single frame of that video they showed yesterday you can definitively say is Tyler Robinson. Also, even the DNA evidence, like with the DNA evidence, another important thing was the DNA evidence, where come to find out they've been saying this whole time, oh, we've got Tyler Robinson's DNA, we've got him dead to rights, his DNA is on the gun, his DNA is on the screwdriver and the towel and blah blah blah. That's all complete lie. Absolute complete lie. Mm-hmm. The only DNA they can definitively say is on those items is Lance Twiggs. His is the only that is 100% on those items. Now, the state does say that Tyler Robinson is a possible contributor to the other DNA because there are multiple DNA profiles on those items. So the state is saying that he's a possible contributor to the other DNA there. However, what the defense pointed out yesterday towards the end of the hearing is that the DNA analyst they're saying that the DNA analyst wrongly labeled him as a possible contributor. He should not have been labeled at all as a possible contributor, meaning they do not have his DNA at all, because the way they were saying is, like, there's a certain criteria you have to meet, and if you like, in order to be included as a possible contributor, you have to score a 20 or greater. And Tyler Robinson only scored a 12. I think it was a 12, might have been a 14. It was either 12 or 14. So he scored under that 20. So therefore, he should not have been included as a possible contributor. Now, the DNA analyst tries to argue that the reason they included him is because that there are three or more, that there were three possible contributors on the item. But the problem is the DNA analyst originally said there were two possible contributors, not three. And the only reason that they said there were three contributors is because the state manually told, or wait, it might be the other way around. Hold on, let me read my post, because I said it better in this post. I think I'm saying it backwards. I want to make sure I get what I'm saying correct.
So just
Okay,
so
so
we're
the
clear,
DNA
oh, you got it. Go ahead.
So the DNA analyst testified that they had a conversation with investigators about whether Tyler Robinson should be included as a DNA contributor on the evidence. Oh no, I'm sorry. Lance Twiggs should be included as a DNA contributor on the evidence. The investigators reportedly said no. I'm sorry. The investigators reportedly said no, which is why the analyst ultimately went with only two contributors instead of three contributors. Because originally she said three contributors, but because the prosecution told them not to include Lance Twiggs, then it went down to only two contributors. And the problem with that is the only reason, well, them adding Tyler Robinson as a possible contributor, the only way you can add Tyler Robinson, could say that Tyler Robinson is a possible contributor, is if there are three or more possible contributors. Then you can include somebody if they fall under the the threshold of 20. But because it should have only been two contributors, not three. If it's two contributors, then it's a hard 20. You cannot include anybody under that 20. So because of that, Tyler Robinson should not have been added as a possible contributor. The only reason they got to three was artificially, only because the prosecutor told her to add Lance Twiggs as a possible contributor. That's the only reason. Had it not been for that, it would still only be two, not three, which means they could not have included him as a possible contributor. So you can tell that the only reason they did that was so they could go on TV and lie and say that they had Tyler Robinson's DNA when they didn't. And like I said,
they just want his name attached to it.
Correct, exactly. That's all it's about. And even if you do agree with that, like I said, Tyler Robinson is only listed as a possible contributor. They don't even have enough to say it's definitively him. It's just a possible contributor. Like I said, he tested underneath the threshold to even be labeled to be even labeled as a possible contributor, but he tested well under the threshold. So like there's some possible DNA on there, but it's not enough for them to make a determination. And so the only person that they can definitively say DNA is on those items is Lance Twiggs. And like I said, the footage they showed yesterday is not Tyler Robinson. They can't prove that that's Tyler Robinson, so they have no proof. The only evidence that they really have that Tyler Robinson is the one that did this is basically this testimony from Lance Twiggs. That's basically it. That's all their evidence. So that's why this is so important.
Well, yeah, the only compelling evidence they have is the video footage that does not definitively identify who that is, actually. And one thing you didn't mention is the note. They consider that note to be compelling evidence. The one where they claim that Tyler Robinson said, "Hey, I found an opportunity to kill Charlie Kirk." Do you know what I'm talking about? They think that's compelling evidence. Have we seen the note?
the note doesn't exist. That's the thing. The note got either he burned, like supposedly he left it, according to Lance Twiggs, he left it underneath of the keyboard for Lance. Tyler wrote that note and left it underneath the keyboard for Lance and told him to destroy it, which Lance did. Supposedly after he read it, he destroyed the note. But the prosecutors are trying to claim that they were able to piece the note back together again after it was already destroyed, which I don't know. I kind of call bullcrap on that. But even so, like, I don't think you're gonna be able to prove that it's Tyler Robinson. I think if there was a note at all, I think Lance Twiggs is either the one that wrote it. Well, yeah, I mean, yeah, if there is a note, Lance Twiggs is the one that wrote it. And as far as the text messages, they were made by a cop, it sounds like. I mean, you heard those text messages. They were like honestly, it sounded like a bunch of Israelis wrote it, honestly, using like a translation service. It sounded like, Israeli cops wrote it, and they were using there's like a translation difference. That's what it sounded like to me. And then the Discord messages where he supposedly confessed as well. We've proven that they're fake, because even today, once again, Brian Davis confirmed that Tyler Robinson was already in the Washington County Courthouse before those Discord messages were written. So there's no way Tyler could have written those Discord messages, which should prove right there who else had access. There's only one other person that could have access to that Discord, who would have access to his passwords and stuff, and that's the guy living with him, his boyfriend, Lance Twiggs. So I don't know why they gave I know why they gave him immunity, because he's clearly a CIA asset. They're protected him, but he's clearly the one. He's got the bullseye on him. He's the one they need to be looking into. He set Tyler up clear as day.
Oh, they know that. Yeah, they know that. And honestly, as far as I'm concerned, they have no compelling evidence right now. If it's just that footage, the note, and what's the third thing? They burned the note.
Yeah. They supposedly that he burned the note, but they claimed that they were able to piece it back together. And I guess got a photo of it or something.
Well, even if they had it, it'd be inadmissible.
It should be, but this judge is admitting everything. Like I said, even though Tyler Robinson's DNA is not even on these items, and the defense basically proved yesterday that his DNA should not even have been, he should not even have been included as a possible contributor. No. The judge is basically like, yeah, I don't care. Who cares? We're going to let it ride anyway.
Well,
I'm like, really?
That one guy on the... Yeah, I mean, that judge is ridiculous. That guy from the defense side that was like, you could tell he was walking on eggshells and trying not to piss off the judge. But you know how he was asking the judge, maybe this is what I didn't quite understand. So he said that he wanted to give a redacted version of the transcription of Lance's interview, right?
Jack, yeah.
So what is the defense side wanting to redact? The police that led the conversation, the cop that led the conversation and practically prompted Lance Twiggs?
That's part of it, yes. I don't know, like, in full what they want to redact, but that's definitely one of the things that they said they wanted to redact was anything that's not Lance Twiggs. So basically, this, the other cop, I forget his name, Matt, whatever, I forget his name, but the other cop that was basically just coaching Lance Twiggs. So such and such happened, right? And Lance was like, yes. So such and such wrote these Discord messages, right? Yes. So they want to cut out what the cop said. And
I would think it would help more to leave it in there.
I mean, exactly. I mean, I get what they're saying. It should not be admissible because it's not, it's hearsay. Like it's not him actually testifying it. But at the same time, I think the public needs to hear that, because the jury is going to be able to pick up on that. If the jury sees that they're coaching Lance Twiggs and what to say, the jury is going to pick up on that and know that he's not a reliable witness. That he's being told what to say. He's being fed, spoon-fed, basically what he's being coached, being spoon-fed, what to testify to.
Right. That just, all of this, I want the audience to take a note, which I know they're already going to, everything that they're not going to show us. Like, they're leaving out, all the evidence, literally.
It's because of this judge. This judge is, well, actually, it's not because of this. It's partially because of the judge, but it's also partially because of the defense. Because the defense are the ones that keep fighting. And that's the thing that really pisses me off, is the defense is actually the ones that are fighting for all this evidence to be seen. They want to hide all this evidence from the public. And there's no, why? The public is your best weapon. The only reason that they have so much evidence that they have now that proves the reasonable doubt that Tyler Robinson was not the one that did this, and has a good chance of getting off at all, is because of us. You think they would want us to see the evidence, but no, they've been fighting tooth and nail to try to keep the evidence from us seeing the evidence. Not only that, but they've been fighting tooth and nail to seal all these court hearings and have private, sealed hearings and sealed testimony. And it's just, you can clearly see that his defense is not working in his best interest. His defense is corrupt. They're working for the deep state. The judge is corrupt, working for the deep state. And obviously the prosecutors are corrupt and working for the deep state. This is just a show trial. That's all it is a show trial.
This is a complete, yeah. And it pissed me off. The judge was trying to be condescending and be like, it's not my decision on how you all want to represent your case and the counsel and stuff. I'm like, yeah, it kind of is. I mean, he's saying exactly. That's on you all. And it's just and he tried to be condescending and be like, I've worked with very skilled attorneys, basically saying they're able to make their own decisions and all this other stuff. So I don't know where he's going with that.
Yeah, I don't know either. It pissed me off, though. Like I said, I have not been impressed with this judge at all. And once again, not only are the cops, a lot of the cops that were there, the local cops, not only did a lot of those cops, which I thought was weird, but a lot of those cops were transferred elsewhere after Charlie Kirk. After the Charlie Kirk thing, they were all transferred to other departments and transferred elsewhere. And a lot of them went to the American Fork Police Department, which, like I said, is a corrupt police department. That right now they're in a lot of trouble for how they handle with intimidating people and violating people's constitutional rights. Reckless Ben in particular, but with the bricks and minifigs case or whatever, the Lego thing that's all over everywhere. And by the way, the judge, Tony Graff, this same judge is the same judge that was a dickhead in that trial too. And he violated Reckless Ben's constitutional rights.
That's what I'm saying. This is definitely a show trial for sure. And it seems like the Judge Graff is just trying to run the clock out.
Yeah.
Hey.
Hey, Jennifer. Good to see you. To answer that one question I had on the screen, yes, they are. Lance Twiggs' DNA was on the rifle. Absolutely. His is the only one that was on the rifle. Like I said, Tyler Robinson is only listed as a possible contributor. They can't say for sure, but Lance Twiggs 100% definitively is the only DNA that they can definitively say is on the rifle, is on the screwdriver, and is on the towel. And another thing that's important is in the car that they showed on that video yesterday, which is purported to be Tyler Robinson's car. They have, there were 3 other people in the car with him. So they were, or I don't know, with 3 other people or 3 people total, but there were 3 people, at least 3 people in that car. So he wasn't by himself. Whoever was driving that car wasn't by themselves. There were at least 3 people in that car with him. And like I said from day one, I do not believe that the person in the stairwell that they captured of the suspect is not the same person. It's multiple people. You know, I think that the person in the maroon shirt is different than the person in the black shirt, for sure.
Yeah, I think they had a couple, maybe 3, a couple patsies that day doing different things, you know, at different locations at different times that have similar build.
Absolutely. Betty here says the driver was bald-headed. Jennifer said, hey, Colin, I need you to do what Candace Owens does. Make a set time, daily or weekly, to come on. Yeah, I'm not really, you know, I'm not really a live stream guy. I don't really like doing it. Also, another reason I don't do it is, like I said, I'm not monetized on YouTube, so there's not really any incentive to do that. You know, if I were to get monetized, you know, then I probably would, but YouTube won't let me monetize. They just refuse to let me monetize because I had a big falling out with my ex-partner, and a whole bunch of stuff ended up happening where he got me banned and a whole bunch of stuff. So they will not let me. They refuse. They will let me have a channel, but they won't let me monetize it. Doesn't matter, even though I've hit the, you know, obviously I'm way past that. You know, I could like, if I was anybody else, this channel would be monetized, but they specifically will not let me monetize because of that. So I'm kind of in a rock and a hard place there. It sucks because everybody else gets to get paid for their work, but I don't, you know, and that kind of pisses me off. But at the same time, whatever. I'm not in it for the money, but it would be nice to, you know, it's nice to at least get paid for your time and effort. Everybody else is, you know. But yeah, I'm not really a live stream kind of person, though. I really don't like doing live streams, to be honest with you, though. I do them if I got something important to say or whatever, but I'm not really I don't know. I just don't like live streaming. I have appealed the decision multiple times, and they keep denying me.
That's crazy. I've never even heard of that, especially on behalf of a third party.
Yeah, well, I've actually made new channels, and they same thing. They've denied them. Well, actually, they haven't even denied. They've actually just banned those channels. They've taken them down. I've started new channels. They've completely just, without having violated any of the rules or anything, they just took them down completely. And that's because YouTube has facial recognition now in place. So they have my face, and they know if I start another channel, or my voice, if I start another channel, then they automatically associate it with me, and therefore won't let me do the thing. It is ridiculous. YouTube sucks. I can't stand YouTube. And I am on Rumble, but Rumble doesn't pay that well, and there's barely any viewers, so it's not even worth it. Like, I've been on Rumble for probably a year now, and I haven't even made enough. You know, the minimum threshold to cash out is $50 on Rumble, and I haven't even made the $50. I'm still at like $35 or $36. Every time I go a live stream to Rumble, I'm only making like 8 cents per live stream, which is crazy. It sucks. Hey, what's up, brother? Good to see you. Shame you couldn't make it today, but we'll see you back here tomorrow.
That's cool. I like his name.
Yep. Be safe, though, man. Be safe out there. Yeah, it does. It definitely does.
Yeah.
I am monetized on X though, so that's why I'm primarily on X. You know, that's why I put out my posts and stuff on X. But as far as like live streams and stuff though, YouTube is where it's at if you're going to do the live streaming, and unfortunately, they won't let me monetize. They were supposed to be back already. Actually, let me make sure I don't have it like paused or something, because they were supposed to be back. Yeah, I got it. We're still on. Yeah, they were supposed to be back at 5 o'clock, so they're 18 minutes late from the break for whatever reason.
Dang.
I don't know what's going on.
Well, so here's my whole thing. If they're going to move forward after...
Go ahead.
Sidebar. I was just saying, if they're going to move on...
I was going to say that with the recess, they weren't supposed to. The whole thing is they're not allowed to do a sidebar. Right now, if they're still in a break, that sounds like they're all colluding behind the scenes, talking about what they can and can't do. The same thing that the judge just said. You know, I mean, not the judge, but the media lawyer just said they can't do without having a hearing. So it sounds like they're violating all of our rights by doing that now and colluding behind the scenes to do this here, to do this in the darkness instead of in the light, so the public can't see what they're doing. They're taking a break to worship Baal. Absolutely. Absolutely. I totally believe that. What's going on here? Yeah, we're still on break. Oh, let me go to the Buy Me a Coffee real quick and see if anybody sent something. See if you guys have said anything real quick. That way I can read them out if we have any super chats. Did I refresh it? Make sure I refreshed it. Okay, cool. Okay, yep, nothing new. So just from yesterday.
I was going to say something. So obviously this is the preliminary hearing. They're seeing if there's enough evidence to move forward. I mean, I just don't understand if they're going to redact everything and not show anything, or, I mean, how are they going to move on to evidence? And then I would think if they're shady, they don't want to move forward, but then it would be kind of a disservice to the American people to not, give this a fair trial.
Yeah, I don't know. I mean, from what it sounds like, there's significant redactions that the defense wants to do. So, to me, if they're successful in getting it all redacted, there's nothing going. There won't be anything for us to look at. There won't. I mean, because it won't make any. It won't. There will not. It'll be out of context. We won't be able to make sense of anything. If they cut out everything of where the police are prompting him with what to say, and they just leave Lance Twigg saying yes, no, maybe so. So it's the whole, you're going to listen to like a 5-minute tape of just yes, no, yes, I don't know, yes, no, but you'll have zero context of what he's saying yes or no to or anything. So I really don't know. It makes no sense.
But as of late, we do have more evidence against Lance.
There's a lot of evidence against Lance. Absolutely. That's the thing is that, I don't know why they're not looking at him. I mean, obviously I know why, because like I said, he's a CIA asset and they're protecting him. But there's a lot of evidence that suggests that Lance was involved, and not only was involved, but he was the one that set up Tyler Robinson. So you guys want me to react to the Ben Shapiro thing that Candace said? Absolutely. Basically, so Ben Shapiro admitted on his stream that he was getting that his security team was getting live updates from Charlie's security team that day in Provo, from the hospital, on the way to hospital, whatever. So obviously that's important because we know that the very first person that knew Charlie, or not knew, but the very first person that posted publicly that Charlie was dead was Emir Tesfari, or whatever his name is. And we know who he is, right? He is a former, well, I don't know about former. I think he still works for them. But he's Mossad. He's a Mossad agent. And secondly, he used to be in the Israeli version of the FBI, or he may still be. I know he was. I think he still is. So we know he would get his information. And by the way, anybody who knows that Amir guy, he always seems to have information before anybody else. He knows what's going to happen before anything else happens. So he definitely has connections in the Mossad government and with Benjamin Netanyahu. And then obviously Bibi Netanyahu, Victor Marx was the second person to say it, but then the third person to say Charlie was dead was Benjamin Netanyahu. And the whole Ben Shapiro thing is important in the context because most likely what that proves, if Ben Shapiro's security team was in contact with Charlie's security team, that proves that Ben Shapiro was feeding information about hey, is he dead yet? Is Charlie dead yet? Making sure he was dead to Bibi Netanyahu and the Israeli government, which is obviously why Amir and Benjamin Netanyahu knew Charlie was dead before anybody else. So yeah, it's very, very important.
That pisses me off. That pisses me off. Ben should have. There is no reason other than that Ben should have been on the phone with them during the transport. No reason whatsoever.
No, not at all. And also, Ben Shapiro has also been heavily involved, way more involved than he should be. He's been more, like Candace said, he's been more emotionally involved, in this since the beginning, trying to get Megyn Kelly to renounce Candace Owens. And, even like he was the first one to say, like on the day Charlie died, he was like, I'm going to pick up I'll be the first to pick up Charlie's bloody microphone or whatever. Who says that? And then them bringing him onto the AmFest stage or whatever, which Charlie hated Ben.
Yeah.
So for that to happen, it's absolutely insane.
Yeah, Erica let him open up the whole thing.
Yeah. And now the context makes sense because now we know why. Because he was getting fed information. He was part of the cover up too. He was part of not the cover up, but he was part of I think he was part of the assassination is what it sounds like.
Yeah. And I think these people look utterly ridiculous. Like you said, he's way more emotionally invested than he should be. Yeah, because Charlie didn't even like you. Candace didn't like you. Nobody liked you until you wanted to overthrow Turning Point.
Exactly. And then the other thing that came out in the trial yesterday that was important is that the suspect that they're saying, obviously they say it's Tyler Robinson, but I call bullshit. Like I said, there's nowhere in that video that you can definitively say that's Tyler Robinson. And I think it's multiple people.
No.
But they're saying that the suspect went up and walked out to the courtyard or the amphitheater and met with a representative from TPUSA. So somebody from Turning Point was colluding with the suspect. That's how I take that. And I would like to know who that person is. And by the way, we know this is true because I don't know what possessed him to do this, and he really put his foot in the mouth. But Blake Neff he went on a Spaces last night, a X Spaces, for us, and one of our guys, one of our investigators went on a Spaces with them for about 2 hours and answered a bunch of questions. And one of the things that he confirmed during that Spaces was that, yes, that is true, that whoever the suspect is did interact and had an interaction with a Turning Point representative. He would not say who it was, but he did confirm that it did happen. But I would like to know, like I said, I think it's important for us to know who it is, especially in the context, like, because it would be very suspicious, like, for example, if it happened to be Terrell Farnsworth, who is the guy who took down the cameras and everything suspiciously. Well, if the Tyler, if they're supposedly the person they say is Tyler Robinson was colluding with Terrell Farnsworth, the guy that took down the cameras and tampered with the evidence, that I think that would be pretty relevant, wouldn't it? I think it's very important to find out who it is. We need to know who it is.
Yeah, and why are we just learning about this?
Exactly. Yeah, why haven't they said anything this entire time? Why are we just finding out?
That would have been
now?
the first. That would have been the first thing that I would have done, is brought that witness or whoever came in contact with Tyler Robinson. I would have had him on the Charlie Kirk show, or interviewed by law enforcement. Well, what did he say? What was the interaction like? What was he wearing when you saw him?
Yeah, why didn't they exactly? Why did they not this whole time they have not mentioned that, not hide or hair of that whatsoever? And that's suspicious. The only reason, like I said, the only reason that they would not do that is if they're trying to hide that for some reason, because they know that they're colluding with them. That it's not just some innocent interaction, that they were colluding. By the way, what's up, D. Anderson? Good to see you, brother. That's another guy you should follow. He does good work. Follow him on X. I have no idea. Like I said, I think that they're doing, they were only supposed to be on break until, until 5 o'clock. So they're already a half hour late here. So the only reason I can think that they're still on break is because they are doing exactly what they were not supposed to be doing. The thing that they wanted to close the hearing in order to discuss, what evidence comes in and what evidence doesn't comes in with this Lance Twiggs testimony. And the media, the lawyer for the media, pointed out that they can't do that. That by law they have to give a hearing. They have to allow for a hearing. If they want to close a hearing, if they want to close the hearing down and have a closed hearing, they have to have a hearing where everybody can argue their case of whether the hearing is closed or not. And we didn't get that. And I think that the judge is going around that by colluding with them behind the scenes, off the record, which is illegal. Honestly, that's something, to be straight honest, if that's what they're doing, that's highly illegal. I forget, there's a name of it, but that's something that could actually get the case completely thrown out on appeal. That's what they got caught doing. Was it Young Thug, or I don't know, one of these trials recently? But when they got caught colluding with the prosecutor, not the prosecutor, but with the judge, when the judge and the prosecutor got caught colluding, having a meeting behind the scenes that wasn't on the record, because that's illegal. They're not allowed to do that. Any time that they have, talk anything about the case, between the judge and either the defense or the prosecution, it has to be on the record. They're not allowed to do it off record. So if they're doing all this stuff off record, that is a very, very big deal and something that could very easily get the whole case thrown out on appeal.
Who knows? Utah probably, just like the hearsay law that they might have a law that they can do that.
Yeah, I know it was one of the recently it was a young black rapper, high profile one that recently went to trial, I think in Atlanta. I think it was Young Thug.
Yep.
It could have been somebody else. I don't remember, but I think it was him. But yeah, that was something that came up in that because they caught them doing that in that hearing. Matter of fact, they even tried to lock up the defense. Huh?
That was Fannie Willis, wasn't it? That was Fannie Willis, the one that got in trouble. She had that case originally.
Oh, I don't know. But I know they even tried to lock up the defense attorney for basically calling them out for doing it, which is even crazier. Young Thug Rico case. Yeah, absolutely. Yep, that's what it was.
Yep.
Pretty sure
that was Fannie Willis in Atlanta.
Okay.
She was trying to do the RICO case on Trump.
Okay, yeah, I didn't know she was involved in the Young Thug thing too.
Yeah, that's super corrupt. Georgia, that's super corrupt.
Yep. And while we're waiting on them, here's one more thing as well. In that, remember I told you last night that Blake Neff kind of spilled his guts on a X Spaces and didn't do himself any favors. Like I said, he really put his foot in his mouth and screwed the pooch. But one of the things that he really messed up on, which is really going to get, honestly, this is a big deal. He threw Andrew Colbert under the bus. Very, very big. Like what he said last night proves that Andrew Colbert had foreknowledge that Charlie was going to be killed that day. And that's a big deal. So this is the post. Let me make sure I'm showing. I think I'm showing this on screen, but okay, yes, I am. Okay, so yeah, well, I'll let you listen to this first. We'll listen to this first, and then we will. And this is from the X Spaces.
And really quick, when
night.
Jack was on the show, or he was reporting live. So when did then he wasn't able to come, but when did Andrew fly down from Phoenix?
Fly down that day. He flew down that day, or flew up, I should say.
From where?
From Phoenix.
Oh, okay.
Or for wherever he flew in from. I don't want to say from Phoenix.
Santa Barbara.
And really quick,
okay, so obviously he just confirmed last night on that live Spaces, he confirmed that Andrew Colbert flew to Provo from Phoenix, not from Santa Barbara. And that's important because remember, Baron Coleman and Candace Owens, both of them did episodes talking specifically about that point and how if it's proven because of time-wise how it lines up, the jet, because the jet that the jet that left Phoenix, Charlie's jet that left Phoenix, compared to the one that left Santa Barbara, time-wise, it proves that he would have had to leave before Charlie was killed in order to make the jet in Phoenix. So that basically proves that Andrew Colbert had foreknowledge that Charlie was going to be killed, which means he also faked his live stream that day. He pre-recorded the live stream with what's his face? Nick Shirley. That means he would have had to fake the live stream with Nick Shirley in order to make that jet in Santa Barbara before Charlie was killed to make it to Phoenix to be on that jet coming down. So there's no way around it. And I'll just read my post here, which kind of sums it all up. Let me make sure they're not back yet real quick. No, they're not back. Okay. All right. So yeah, so Blake Neff, longtime producer on the Charlie Kirk Show and one of TPUSA's most vocal defenders of the official narrative, the Fed slop, slipped into Louisiana Girls' late night impromptu spaces and said Andrew Colvett, and confirmed Andrew Colvett flew into Provo from Phoenix, then immediately tried to walk it back. So this is what Blake said. He said, he flew down that day, or flew up, I should say, from where? From Phoenix. Oh, okay. Or for wherever, or for wherever he flew in from. And then he tries to say, oh, I don't want to say Phoenix. So then he tried to walk it back after he knew he put his foot in his mouth and said, oh, I don't want to say Phoenix. Because he knows what that implies. If he admits that Andrew flew in from Phoenix, he knows exactly what that means. So the question came from Charlotte Lee, 88, which is Charlie's Angels, 47 on X. Go follow her. She's another one.
I follow her.
Good researcher. Yep, she's a good researcher. Comes up with a lot of good stuff. So the question came from her. Multiple people in the investigator community already clipped and noted it last night. Why this matters? For months, the maintained story from TPUSA insiders, including Andrew Colvett and Blake Neff, has been that Andrew Colvett flew from Santa Barbara to Provo on 9/10, arriving in time for the now famous tarmac hug with Erica Kirk. Candace has repeatedly pointed out timeline problems with that story. Flight data showing movements involving the Santa Barbara to Scottsdale, Phoenix area corridor flight right around or after the shooting. Place scanner audio indicating Erica was already being picked up by 3:30 p.m. Questions about where people actually were and when they moved. If Colvett was flying from Phoenix or was positioned such that Phoenix was the accurate origin in Blake Neff's mind, this directly undercuts the Santa Barbara narrative they've been defending. The instant backtrack, I don't want to say from Phoenix, is the kind of tell that happens when someone realizes they just revealed something they weren't supposed to. This doesn't happen in controlled interviews or on their own show. It happens in open spaces with Charlie Kirk investigators asking direct questions. So that is actually huge. That is a huge deal. And this is
Barron's timeline, there's no way this couldn't have been pre-planned, is what he said.
Yeah, so this says here, Andrew Colvett lives in Santa Barbara. His jet N560TW left the gate at SBA at 12:37 p.m. Utah time. Arrived in Scottsdale at 12:44 Arizona time. Charlie's jet N102D7 left Salt Lake City 37 minutes after Charlie was, and then arrived at Scottsdale at 1:13 p.m. So obviously the whole point is if he flew to Provo on Charlie's jet from Scottsdale, Arizona, that means he had to have left before Charlie Kirk was killed. All right, we're back. So let me pull this back on now here. Finally.
Concerns that my decision will be influenced by undue prejudice as that of a jury. Therefore, for purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript, and again, State's Exhibit 16, that may not be admissible at trial and whose relevance I have not yet determined. In the abundance of caution and to protect the jury pool, the potential jury pool, from hearing potentially inadmissible evidence, I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255, until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one portion. And when I say audio, I mean audio and video. So both. I recognize there's approximately only 1 minute after 3548. The state can fast forward to that point for it's an approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today is up until from the beginning until that page 19, 3255, that portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going to allow to be published. And I wish to differentiate. I'm considering it all. But for publication purposes, that portion is not going to be permitted to be played in the courtroom.
Your Honor, would you state those times again that you are ordering not to be published? I've got 3255 to 3548.
Right. Those are the two timestamps for that. And I hope that's helpful as both parties are trying to review on the transcript and in State's Exhibit 16.
That's from 3255 to 3548.
Right. Is not publishable in the courtroom or on to be broadcast.
Okay.
Finally,
so
I want to recognize both parties wanted
They're
the benefit
saying
of the
3
record
minutes
to
of it
be
are
more
not
specific
able to be
in their
publicized, but the
arguments
rest is.
concerning
I think
their objections.
that's what
So
he's
if
saying.
those
I think.
arguments pertain to timestamp 3255 through timestamp 3548, I'm willing to allow you to do that in a closed hearing. Please be mindful of the time and keep your argument succinct. With that in mind, do the parties have any arguments they feel I have not considered in my ruling that require a closed hearing?
Yes, Your Honor. And so I'm just going to tell the court what I think the general nature of that is without getting into the details, because I do think a closed hearing is appropriate. There are, okay, setting aside the 1102.
I'm getting so sick of these guys.
There are statements in this video
There's nothing but
by
corruption.
Mr. Twiggs attributed to Mr. Robinson. Okay, Mr. Robinson said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay, I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule. But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published.
I know, right?
Considered by the court.
Crazy.
Published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we're
playing it. What are you talking about?
It's
playing. It's on the screen.
Publication.
It's live. We're on screen right now.
Especially on, in the way this proceeding is being published, would violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different. But because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532, the following. In Rideau versus Louisiana, and that's R-I-D-E-A-U, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson confessions, but that is what the state will call them. And so there are portions of this exhibit and the other exhibits that I've referred to, which implicate Mr. Robinson's right not to have what the state calls a confession televised. This court has authorized the televising of this proceeding. And there are reporters in this courtroom who will go outside and speak on what we used to call television. That opinion was from the 60s. Now we have other forms of technology, but I'm just going to use what the Supreme Court says because it's the Supreme Court. So we are very concerned that the publication beyond this court's eyes of what the state will call confessions at trial violates Mr. Robinson's due process rights right here and now today. And I know that we said that before in the litigation, but now we're exhibit specific. If I haven't been clear about the argument, I want to make sure I'm clear about it, because the court's decision to allow this video to be televised and the other two exhibits to be shown to the camera in the back of the courtroom is exactly what the Supreme Court says.
I know, it's ridiculous,
the 14th
man.
Amendment.
So, and I appreciate that clarity, and
they're
perhaps,
insane. They're absolutely
again,
insane.
If you want to go into closed hearing, we can do so, or if you want to refer to the pages. So I want to know exactly what you're referring to, whether it's in that 3255 through 3548, which is being excluded, or is it? In the
It is not. It is earlier, and it's also the two other anticipated exhibits. So we may as well deal with all of it at the same time. It's probably easier to do it in a closed proceeding because nobody has to be obtuse. I don't have to be obtuse in order to protect my client's rights.
No, I appreciate that. And it actually prompts, in order for me to get to that, I do want to ask the state, are you intending to introduce the text messages as an exhibit in this proceeding, the preliminary hearing?
Yes, Judge, we will be attempting to and moving for the admission of the text thread, the Discord thread, and I think, and the
How are they still going to
note
try
that
to
was
put the
referenced in
Discord messages
Mr.
in
Twiggs'
as
11th.
evidence
All right,
when
let me
we've
take
proven
one
they're
step
fake?
at a time, just for clarity. And again, Mr. Novak, I really do appreciate you being so precise. It's helping me parse it out so we can address it, because it's important, and I recognize that you're advocating for your client.
Well, he shouldn't have to draw it out for you, but okay.
The text messages, from my understanding, and either side weigh in, my understanding that those were released to the public months ago in their entirety.
Judge, if I may, they were not released in their entirety. Portions of them were placed into the charging document, the information that supported in part the charges that the state has filed. We did not put the entirety of them in. And now we wish to publish more of them than were included in the charging document.
I see. For some reason, I thought it was as part of an exhibit for a
Really?
motion, but
Doesn't surprise
Mr.
me. She
Novak,
did
I'm
the
not sure
first
if
day.
that's, ringing any bells. I'm
aware of the issue that the court is commenting on. I think the state needs to account for its decision to publish text messages that directly implicate the Supreme Court law that we're talking about. And don't want to pretend that I can anticipate what the court's concerns are, but that doesn't cure republication on television of what the state will call.
That's the whole thing, you know. If they want us to buy their Fed swap, then they need to show us the evidence.
Bag or the barn doors open. This is another opportunity to violate Mr. Robinson's constitutional rights. And I'm not at all suggesting that somebody is intending to do that. Certainly not the court. And I'm confident that the state's counsel would never intend to do that. But that would be the consequence of further televising what the state refers to as, previously referred to as confessions, and certainly would refer to here in this proceeding as confessions. We are so acknowledging that they are statements of a party.
We need to hear what Lance Tweak said. Simple as that, okay?
We have not filed anything
out of the bag.
In this
Let us
case
hear it.
that publicizes the text messages, the Discord chat, the note which Ms. Hunt is mentioning, and now that Ms. Hunt has said that, yes, we want this note to be presented into evidence, and the court knows what this note is because the court's now watched the video. That's another piece of the same problem. So this is all simplified by the court being extra cautious about Mr. Robinson's constitutional rights, considering these exhibits to the extent the court deems that they're admissible and portions of them are relevant, and not further televising them in this proceeding in a manner which we think is inconsistent with what the Supreme Court said in Estes v. Texas.
All right, I appreciate that, Mr. Novak. Ms. Hunt, would you like to respond? Because I understand what Mr. Novak's saying, and there may be a 403 issue as well as it relates to this, and I'm not going to pretend to read your mind, but because I can't do that. All right, Ms. Hunt.
Just to clarify for the record in the court, the state's position is that we would like the audio played. The audio may be captured by the cameras.
No, I agree, but my point is
never intended
the cat's already out of the bag. You know, at this point, we need to hear everything.
Such that cameras can capture them and you know, pause or get the actual exhibits, substances of the exhibits. I believe that was the media's.
Ideally, they wouldn't let anything Lance Twiggs had to say in as evidence, since he's not there to testify.
Displayed, but the state's position is we just want the audio played.
Right, but what's it? So I'm just focused on 16 right now.
Okay, yes, and that's the state's position with regards to Exhibit 16.
All right, so help me understand what's the difference if the audio's played or the video's played on what the court is identifying is, well, first of all, 16 is admitted, so that threshold has been met, but we're dealing with the publication in regards to what is publicized, because this is going to Mr. Novak's argument about publicizing that is different than the court simply reviewing it in its own privacy. I don't want to misstate your argument, but I believe that was one of the distinctions you made.
The distinction that Ms. Hunt is drawing is, I think, what people call a distinction without a difference. It doesn't matter whether it's audio or video, and it doesn't matter whether it's on a television or on the internet or on the radio. It's going to be broadcast. And so it doesn't really matter whether it's audio or video. And it's actually not Mr. Robinson's video, it's Mr. Twiggs' video. And when the court mentioned 403, yes, I think the court did accurately read my mind, which is fine with me, but it's unfair prejudice of a constitutional dimension, and 403 is a rule of evidence.
All right, so Ms. Hunt, as it relates to that publication, help me understand whether it's audio or video. What's the difference there? Help me understand that.
I disagree that it's a distinction without a difference. As we've discussed prior in this hearing, UCJA Rule 4-202.02 sub 2 sub J states that exhibits are presumed to be public court records, and it does give the court discretion to regulate access when necessary to protect the integrity of the exhibit or ensure a fair trial. So I do want to recognize that. But that discretion should be exercised narrowly, as we've talked about before with publication regarding this case. What the state is proposing, we believe, is a narrowly tailored accommodation. We don't want to display the full exhibits. Obviously, within State's Exhibit 16, the video of Lance Twiggs, he is shown, and it can be seen, exhibits that the state will then in the future move to admit 16.1, 16.2, the text threads, the Discord threads. So we're thinking that if it's displayed visually, what the cameras will be able to do is pause that, duplicate them, replicate them, essentially have access to those exhibits. What we're trying to do, and maybe they can do the same thing with I'm sure Mr. Novak will say they'll do the same thing with the audio. But hearing the tone, the context, all of that's why the state chose to do, we could have done a written 1102 statement from Mr. Twiggs. We chose to do, as is allowed by 1102, we chose to do a recording because that's how the state is choosing to present this evidence. We believe that the appearance or the tone, the context, hearing Mr. Twiggs actually talk and talk through these exhibits, talk through his experience is a meaningful way of presenting our evidence. And so that's the difference we're seeing.
I see.
Obviously it's up to the court's discretion on how publication is to be made here. We've made our arguments generally about that
I've reached
issue,
out
and
to him.
We'll submit it to the court.
But he won't
prime
talk.
issue is that
I sent one of my people there, and they actually went to the jail to talk to him.
Consider them as
They
part of
sat
the
face to
preliminary
face with
hearing
him, but
standard and bind
he
over,
refused to talk.
But we'll submit it to the court on publication. But that's the state's position.
All right, Mr. Novak.
I learned a long time ago that when the opposing party says, Your Honor, we're submitting on it, there's a suggestion that maybe the court is going to make a ruling which doesn't require more evidence, more argument from me. But I am going to say that it is fair for Ms. Hunt to say, Your Honor, we wanted the court to see the witness and hear the witness so that the court could make reliability determinations. Because as Your Honor has said, that's really up to you. That's a different issue from the constitutional consequences of electronically publishing what the state will call a confession. Now I've changed the word from television to electronically publishing because I'm trying to be in the 21st century, and the Supreme Court used that word in 1963. Sure. Citation to state standards for what is or is not a public document are not the issue.
Not without their permission.
Here. And I think that
the
court
his team
has already
could,
heard from me at least 3 times about what
the
we think the court
prosecutor
should do
could,
here.
but we can't as the public.
It's a preliminary hearing. It's not a jury trial. There may be a jury trial in the future at which we have to voir dire on yet another issue, which is whether potential jurors were exposed to media replaying of what the state called a confession. That's exactly what was structural error. There was no prejudice question in Rideau versus Louisiana, and that's why in Estes v. Texas, the Supreme Court said, we have a rule. You can't televise what a prosecutor calls a confession before trial. Thank you.
All right, thank you. I appreciate both parties advocating and arguing. It's helpful for the court. All right, so in taking into consideration the argument, which again, I appreciate the parties articulating, the further edits that the court is going to require to be redacted, starting on page 8, and I apologize, I don't have a timestamp. Starting on page 8, and sorry, I'm just trying to. Sorry, starting on page 7, right after 8, is that at 8?
Exactly. That's what really is bullshit. That's why they choose Utah to do this, because Utah allows that. One of the very few states that actually let you do hearsay.
Well, let's start. Starting on page 6. Now, let me go back here. Starting on page 6, after 6 minutes and 56 seconds.
Yeah, that would have made sense to just say that.
Going to 20 minutes and 27 seconds. For reasons such as 403, under Rule 403. And again, this is simply for publication. This is not taking out what the court will consider. The court is considering the entirety of State's Exhibit 16, but the court is trying to take a narrow approach in recognizing and balancing transparency with constitutional rights, and doing so in such a manner that it is meaningful and doesn't diminish the court's duty as a magistrate under the probable cause determination. All right.
State those times again, Your Honor.
6:56 until right the line before 2027. Or 2027, just so until 2027. Is that? And then and then what the court indicated previously from $32.55 until $35.48.
And I apologize, Judge, just to clarify, these timestamps that you just gave, the 32:55 to 35:48 and 6:56 to 20:27, those are just not being published, but they have been admitted for Your Honor's consideration.
Right. So kind of going through my 3-step process. Exhibit 16 is an entirety, not the transcript, but because the exhibit is not the transcript. The exhibit is the video. That has been admitted in its entirety for the court's determination as it relates to this case. So what I'm talking about here is this is only what will be published in the courtroom and on and captured by the video is the differentiation. So what's being redacted, for the lack of a better word, or cut out is what's going to be published in the courtroom, not what the court's going to consider. The court's considering it in its entirety. The court's not going to redact anything in here. It's going to make its own determinations in regards to relevance and everything that everything that Mr. Novak noted. I'm taking that in consideration and making those determinations, which the court will do again, because this is not something you do watch once and then make your decision. This requires analysis, and the court is committed to doing that. But hopefully that gives you an idea of where, as it relates to publication.
Yes, thank you.
All right, to the media.
So out of like a 45-minute video,
Your Honor, I
they
know how much
only
time
want
the
to
court's
show us
already
like a
dedicated to
6-minute
considering this, and I
section.
appreciate the additional time being afforded the media. There's just two additional things that I wanted to mention to the court. I do want to reiterate the point that I made before about the fact that if this is, in fact, a key consideration that the court is entering into when trying to make the determination that it is going to make at the conclusion of this hearing, Utah case law, including the Archuleta case, that the defense has referred to over and over again, stresses that the same considerations that urge for access to a preliminary hearing itself, allowing the proceedings to be televised, allowing people to be in the courtroom, also advocate for access to documents on which the court bases its ruling. Disclosing documents used, this is from Archuleta on page 238 to 239. Disclosing documents used by courts in reaching a decision in a preliminary hearing will discourage decisions based on improper means and will promote conscientious performance by all officials involved in the criminal justice system. Therefore, providing a presumptive right of access to documents filed in connection with preliminary hearings can play a significant positive role in the functioning of that process. I want to reiterate the belief that providing access to the documents on which the court bases its decision in this proceeding is critical. Second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I understand from the arguments being made today that many of these references are to text messages. Again, the public doesn't yet have access to that. But I do believe that the documents filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if this information is in the public already, I shouldn't be in the business of trying to now keep that from the public for two reasons. One, it's already out there. Second, it suggests to the public that something else lurks in there. Something else is being kept from them that isn't. And so not only does it run counter to the idea that of transparency generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this that are already public. And so I again, recognizing how much time the court has already invested in this, I believe it's wise, and I believe it would help avoid potentially making a mistake that the court later on then thought, oh, I wish someone had brought that to my attention, to check whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case. That's all I had, Your Honor.
Thank you. And all right, counsel, if you would like to state your name.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand it's the state, the defense, and the judge. You're all doing your job. But I feel as if we need to want to be clear as to what the Kirk family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to. That's it, Your Honor. To not be transparent here, to not be open, to not let the world see what happened will create doubt and distrust in the judicial system.
Yes.
And that's not what anybody wants. That's not what any of us believe should happen here. and we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you.
Fuck the family, but I do love your
Anything
argument.
further before I issue my final ruling to clarify what's been stated, just so it's clear to all parties? Mr. Novak, and that your mic's muted.
He's exactly right, though. It will create distrust
Yes, we just want to say that
in the judicial
we
process.
totally respect Ms. Kirk's position in this situation.
Yeah, that was the lawyer that
as
sent me my
well
last
stated
cease
by
and
her
desist,
counsel.
though. I think it was the last one, but yeah, he definitely sent me a cease and desist. I remember his name.
Media counsel's suggestion that because the state, in our view, improperly disclosed what the state is going to call a confession in charging documents does not mean that this court can just let it go. This has been the most
It's already out there in the public,
transparent
dude. Just give
criminal
it up.
proceeding I've ever been involved in.
It's already
And I am
out
sure it
there.
will
The
continue
cat's
to be
already out of the bag.
But
Let
there
it
are
go.
some things which the Supreme Court has said the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect Mr. Robinson's right to a fair trial? And with all due
No,
respect,
and then in the jury trial, then they're going to
Kirk
try
family,
to.
with all due respect to the media,
They're going to try to claim that that we don't get to see
the
that either.
number one concern in this proceeding is Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom under this court's supervision with this court's guidance to pretrial information of this nature.
All right, I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is Estes cited to a dissenting opinion in Rideau.
Rideau, yes.
Rideau, my French is bad.
Mine too.
That constructed a rule that publicizing a confession runs afoul of the 14th Amendment. But that didn't appear to be the holding. It was the opinion talked about coerced confessions.
Yeah,
being put out
exactly.
to
The
public.
defense
Would you
is
cite to
honestly, he's
Estes
doing
that
the defense is
supports,
working
the
against
portion that the
Kyle
court is
Robinson's
looking at
best
is exactly what I would read to the court. It says we constructed a rule. Now I understand there's a parentheses there where it refers to a dissenting opinion in Rideau, because I think that was a case where there were multiple opinions. And we all understand how complicated it is to figure out what comes out of a Supreme Court opinion when there are multiple concurring and dissenting opinions. But what the court says in Estes is that televising, I'm going to paraphrase a little bit, televising what the prosecution calls a confession de facto violates a defendant's 14th Amendment right to due process without a prejudice analysis, without even looking at what happened in the trial
The problem is the cat's already out of the bag.
televised analysis.
These text
So,
messages
yes, we could
and
go
Discord
down a,
chats, they've already
you
put
know,
them out.
lawyers like
They've
to do.
already
We could go
said
down
that
the
they're
rabbit
Kyler's
hole of
confession.
what were all the
cat's
different
out of the
opinions in
bag.
Rideau.
It's too late
and
for that now.
Why
You
is
can't hide
Estes
stuff that's
citing
already
to
out in the public.
a dissenting justice? But what Estes said is we constructed
And this
a
is
rule.
under oath.
It's not a reference to a dissenting opinion. And I think when the Supreme Court says we have a rule, we should just take it at face value that that's the rule. I understand what's in parentheses there is a little confusing, but what the Supreme Court is saying in Estes is we have a rule. And if I may have one moment. The Estes opinion was written by Justice Clark. There was a concurrence by Chief Justice Warren, Mr. Justice Douglas, Mr. Justice Goldberg, And then there were dissents by Justices Stewart, Black, Brennan, and White. So we could spend some time deconstructing that, but it's a 5-4 opinion of the United States Supreme Court saying what rule they adopted in Rudeau versus Louisiana. It's a 5-4 opinion. And I would have to sit down with the cases, just like Your Honor probably is wishing it had time to do right now. The court had time to do right now, but it's a 5-4 opinion of the United States Supreme Court saying what the holding in Rudeau is.
Thank you. All right, I appreciate that guidance, Mr. Novak. So taking into consideration all the factors, the previous edits, starting at, I believe I said, starting at 6 minutes and 56 seconds, going to $20 and 27 seconds. Does that comport what I previously said?
Yes.
All right. And then the other edit is from 32:55 until 35:48. Does that comport with what I previously said?
Yes.
All right. And then from 35:48 to the remainder 37 can be included. So there is that gap, but that can be included. And part of the reason in responding to
So he's doing it anyway.
And it's an important point, and to
of course he is.
The representative for victim representative Erica Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line. One of the reasons why for these edits includes under my analysis under 403, going to the last part, needlessly presenting cumulative evidence, and based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, constitutional rights, as well as transparency. And sometimes it is an imperfect balancing act, but I'm trying to act in the interest of justice in making this balancing act and for transparency to actually be transparent. And so that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state, do you wish to make the edits as identified by the court and play it tomorrow to publish it, or do you wish to go a different route?
I think just to make sure that we are completely in line with the court's ruling, I think we would like to take the evening to make sure the edits are all correct and start out tomorrow by playing it.
And if you wouldn't mind, when you have that final copy, if you could send it to defense to review to us to form, just to make sure it comports with the timestamps that the court has identified. And I know this has been a long conversation, but I just want to make sure everyone understands, okay, this is what the court said, and we're all on the same page, that what is before that's being presented reflects that. So not downing the state, simply allowing everyone to review it before it is introduced into court.
Absolutely, we will do that.
All right. On this issue, anything further?
As to this exhibit, no.
All right. Well, Ms. Hunt, let us move forward. Being that you indicated that you're going to prepare this for tomorrow, how would we like to proceed for the remainder of our time together?
Yeah, just a moment.
Of course. And I know the state's engaged, but if someone could send a copy of that to the court after it's been reviewed by counsel, so the court can review it to double check that it comports with what I said, to make sure that it reflects what I was intending to reflect. That way we can save time as well. Thank you.
Yeah, I'm really not happy with this judge.
He's just brazen.
Ridiculous.
He acts like this is a waste of his time.
Yep. He's been very short.
Judge, it's the state's position that we close for
He
today.
doesn't have very much
Come back
patience
once
for
those
people.
edits have been made. We can start tomorrow with that and proceed from there.
All right. Any opposition from defense?
No, Your Honor. I do want to point out that there is one additional exhibit which we think the state will offer through Mr. Davis. I'm sorry, Agent Davis. Agent Davis. As to which we proposed redactions. It's 5 screenshots of Mr. Twiggs's phone. It's not a 25-page transcript. I'm not suggesting that we should argue about that now, but I'm just making the court aware of that. It's a much simpler exercise. It's not nearly as complicated. I think that's the only one where we proposed other redactions. But the publication question still remains as to all of the asserted statements by Mr. Robinson. So it's according to Mr. Twiggs, according to the text messages, according to the Discord and the note. All of that is part of the SD's issue. I just want the court to be aware of that. And I understand it's hard because the court doesn't have all those exhibits in front of it, but I just want the court to understand. I think that all of the argument that we've had with respect to the transcript sort of lays the foundation for the legal issues, but it's going to come up with respect to those exhibits as well. And the comments that the court made about 403, I understand it with respect to relevance and
Amen.
admissibility.
That's
I'm
what
not
it's
sure
all
how
about.
403 applies to
It's all about justice for
the
Charlie.
televising
I wish this
of
court case was about
statements
that too, but
the
unfortunately it's not.
prosecution will call confessions. So maybe
No, this is
that's
about
something.
It was a different prong that I was addressing.
Good. Okay.
The duplicative part or cumulative part as it
Thank
relates
you very
to the
much.
text messages, and that's why I reserved that if it doesn't come in, then it can be revisited to the redactions that's made public.
For evidentiary purposes as opposed to for publication purposes.
Right.
Understood.
Right.
But if the court wants to recess, we have no problem with that.
And so just going to your point, and again, trying to maximize our efficiency, given your arguments, which you articulated well, would you mind perhaps preparing a memorandum or a short brief that can help us move forward? Because I want to look at in detail what you're citing to. It's difficult on the fly to jump into SDs and go to a portion, and I want to give your argument full consideration. It's a suggestion if you can. I know you're extremely busy, but it may be helpful if you choose to. If you choose not to, I will certainly allow the time for it to argument. I just want to make sure I'm fully up to speed as opposed to trying to shoot from the hip there.
When the court says, I'd like to know which exhibits and what the legal issues are ahead of time, so that at 9 a.m. the court has already had an opportunity to understand what's coming, we're happy to do that. And I'll try to get something to the court by 8 a.m.
I appreciate that. Thank
No
you,
problem.
Mr. Novak. And if you wouldn't mind, obviously, sending a copy to the state as well.
Oh, of
so
course,
it's not
of course.
ex parte. All right.
So, is the court referring to a formal filing?
No, just if
A
you
bench
want
memo.
a bench memo, and that all sides can have take a look at, just to prepare, again, in light of efficiency and trying to maximize our time and give as much weight and time to addressing these issues fully, as opposed to trying to hit them at the moment and doing a deep dive when it's a little bit more difficult. So
Happy to do so.
if you'd like to, I would entertain that to the state. If you want to confer and talk to see where you are and want to do the same, certainly you are entitled to do so as well.
I think we plan on doing that. Thank you, Judge.
All right. All right. Is there anything else for this afternoon?
Not from the state.
All right. To defense.
No, thank you very much for your time, Your Honor.
All right. Court will be in recess until 9 o'clock tomorrow morning.
All right.
Okay. Well, we honestly, I wonder whether they're going to be able to finish this before Friday. This actually might, the preliminary hearing might actually stretch all the way through till Monday, because they didn't really get anything done today. They argued about this stupid thing basically the whole time.
That's what I'm saying. It's like they're running the clock out. For what?
Yeah, I don't know about that, because they got to do it regardless. So it's just a matter of.
Well, that's what I'm saying.
Now,
like, why are they? That's what I'm saying. There's no point in, like, I don't know why they're dragging their feet and making things complicated.
Yeah, I don't really get it. I mean, the defense is really, from the beginning, the defense has been trying to, basically, like I said, they've been blocking the public's transparency, for everything. We haven't been able to, but they've been trying to block the public from seeing everything. They wanted to keep the hearings private. They want to make sure that Tyler Robinson can't be seen on camera. They want to make sure we can't see the exhibits in the courtroom. Everything. It's been, they've been really, honestly, they're all in cahoots. Absolutely. All in cahoots together. 100%.
And the defense, his defense team is the worst.
They are. They're horrible. Absolutely horrible.
Yeah.
They are not at
I was
all.
listening to the prosecution, and I was like, well, they're making more sense than the defense.
Yeah, and even Erica's lawyer or whatever, I was actually applauding. You saw me actually applauding when he said that, because I liked what he had to say, man. He was dead on. It would create. He said it would create a what did he say? A mistrust of the justice system or whatever.
Yeah, because like you said, the cat's already out of the bag.
Yeah, I mean, you can't,
and they're gonna lie. Yeah.
Yeah, you can't hide something that's it's already out there. I mean, yes, I get it, you wouldn't want his alleged confession or whatever to be out there in the public, but the problem is they've already broken that rule and done it from the beginning. It's already been out there. Since day one. That's the first thing they were running with is Tyler Robinson confessed. You guys are wrong because Tyler Robinson confessed. We've got all these messages where he confessed. So they've already put out all the messages. They've already blasted that all over the media, his alleged confession. So the damage is already done. The cat's already out of the bag. There's no sense now in trying to, there's no sense in trying to hide it because it's already out there. So the only, them trying to hide it now is only going to make us be like, well, why are they trying to hide it? What don't they want us to see? Which is exactly what Erica's lawyer said was, it's going to make the public distrust the judicial branch. That there's, that they're not doing things properly, and that's exactly, how I see it, and honestly, that's how a lot of people see it.
I mean, the majority, I feel like they don't have the majority on their side anyway. We already have serious doubts about this judge and how this is going thus far.
Yeah, exactly. I agree.
So if they want to make this case worse for them, you know, make them look worse.
Yep. I'm texting Billy real quick, trying to see if
No,
she's
you're
out
good.
yet.
I don't see how redacting things could even be possible.
No, it shouldn't. Honestly, it's like I said, if they hadn't already put the messages out, I get it. Okay. Yes, it would make sense. You wouldn't want that out in the public, but they're already out there. At this point, they're already out there. The public has already seen them. We already know they exist. The only thing that it would do now, honestly, it would help. It would help. Honestly, it would not be prejudicial anymore to Tyler Robinson because they're already out there. The only thing it could do now is like I said, because as we found out, we may not have seen the messages today, but as we found out, Lance Twiggs was being coached as to exactly what to say. You know, he was being fed basically what to say. So to me, that's not prejudicial to Tyler Robinson. To me, that would make it look like Lance Twiggs is setting up, or the state is setting up, you know, Tyler Robinson or whatever, you know, because
yeah,
if anything, it would make Tyler Robinson look innocent because it would show that the state is colluding to try to railroad this guy, you know, by feeding their witness, Lance Twiggs, by feeding him the answers, you know?
Yeah, I mean, I feel like they basically admitted that today, and that's a big takeaway from today is that he was basically prompted. He was coached and he was prompted on what to answer and what to say. So that's kind of a big takeaway from today. I think you're on mute.
Yep. Yeah, so that's a huge takeaway. I'm actually glad that we didn't get much accomplished today. That hearing was pretty much garbage, but we did get that. That's something very important that we got, which is good.
Yeah.
And then, of course, they also released the one video, this one right here. Let me show this one. All right, so they also released a video of Tyler Robinson in custody in the Washington County Jail. So we'll play that again real quick.
Which have been
Does it ever show his face? Because we just saw his back.
Yeah.
Reiterated over the
last I think it did. I thought it did.
We don't need to start over with that today.
Thank you. I appreciate that. I note the standing objection by defense as previously made. And that objection is overruled. And
I could be wrong, but I thought I saw his face.
In this case, it wouldn't be the 1102 issues. It would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right. All right, State's Exhibit 15 may be played.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark colored baseball cap with that's like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's
you're right.
Jeans.
They didn't.
Gray and white.
Holy crap.
No.
Good memory. I didn't even catch that. Yeah, I didn't even catch that. But yeah, they didn't even show his face. You can't even prove that Robinson here.
Yeah, that's not even definitive.
Yeah, look, he's got his face turned away from the camera. You can't even prove that's Tyler Robinson. You got to be kidding me. So they have absolutely zero footage that they can definitively, and honestly, this makes so much more sense now, because remember, when the media, we tried as well, but also the media tried to FOIA the security footage of the body cams and security. We tried to FOIA both the security camera footage and the body cam footage from the Washington County Sheriff's Station or whatever, where Tyler turned himself in. And obviously the body cam of all the cops that were involved in that, and we got denied. And what they say is they don't have any records. They're claiming when it comes to the body cam evidence, they're claiming that none of the cops had their body cams on, which is ridiculous, because that's actually violates their law and their policy. I've actually brought that up, that not only is it the law in that state that they have to have their body cams on whenever they're dealing with a member of the public, but it's also their policy that they have to do it as well. So you're telling me all those cops in Washington County Sheriff's Office that were there when Tyler Robinson turned himself in, allegedly, not a single one of them had their body cam on. They all decided that they were going to break. They were all going to take that moment right there to break the law. They all in unison were deciding they're going to break the law and break policy on the most influential, high-profile arrest that station will probably ever receive in the history of that station. So all in unison, they all just decided to break the law. Exactly, they coordinated in unison all that day to break the law. And then when we tried to get the surveillance video, they claimed that they accidentally deleted it or whatever, so they don't have it anymore. How do you accidentally delete surveillance video of that should have been held for the case against him?
Yeah,
it makes no sense.
That's what I'm saying. But none of this is viable. I don't see how they can use any of this. And that's the only clip that they had. Do you think maybe they're not showing his face in the preliminary hearing, but during evidence they might show his face?
No, they don't have. This is what they have. This is all they have. This is all they have. They do not. I don't think they have anything with his face in it. That's the crazy part. And like I said, this makes so much more sense now with him turning himself in, and Washington County makes so much more sense now because of that fact, because that they didn't, they have no other video of Tyler walking himself in. They have no body cam footage of him turning himself in. All they have is just footage of him from this room where you don't even get to see his face. So was it even him, or was that a patsy too? We don't even know whether that was really Tyler that turned himself in now.
That's ridiculous. They have nothing. I mean, honestly, they have nothing as far as the public's concerned. And that media guy, the media guy that went up periodically to testify, he's the only one that makes the most sense.
Yeah, I agree. He did a great job. I wish he would speak up more often, honestly, because I'm getting tired. There's been a lot of evidence that they have blocked, that the defense has blocked, and the judge went along with it, that we should have seen.
Yeah, that's what I'm saying. I mean, it seems like they want to move on with the trial, but I mean, they're doing more than just trimming off a little fat. They're taking away substantive evidence.
Oh, big time. Yeah. And they want us to, they want to ease our suspicion. They want us. Give me 1 second.
Sure. You talking to Billy?
Yeah, she just got out. Okay, hopefully she'll be on in a few minutes. She said she's doing an interview with a local news outlet, and then she's going to come on with us, hopefully. So we'll stay live until hopefully she does that, and then we'll get off. We'll end the stream after that. But I do want to have her on and see if we can get some information from inside that we weren't able to get.
No, we definitely should.
Yep, absolutely. Just a reminder again, everybody, if you want to send us a super chat, the stream's not monetized, so if you want to support us, you can send us a buy me a coffee right there down the bottom left-hand corner of the screen. You can just scan that QR code on the screen, and you could send us a buy me a coffee. You can send us any amount, $1, $5, $10, $100, whatever you want. Leave a comment and we will read it out like a super chat. We definitely appreciate your support, and I'll go ahead and drop that link in the chat as well for you guys. In case you're on your phone and you can't scan it, you can just click the link. All right. Yep. So there you go. buymeacoffee.com/projectconstitution. Let me drop it in the X chat as well. For all you folks on X. Oops. Well, not really. I need to put it here too, but. Go to the live chat. Come on. Loading.
No, you saw what I said. I think Ben Shapiro should testify.
I agree. He should, honestly. I think they all should testify. Victor Mark should testify. They should all testify. All these people that have had insider knowledge and were in communication, with Charlie's people or Charlie's security that day, they should all have to testify.
In the moment. Literally in the moment.
100%, absolutely.
And
all right,
you heard
so
what
I just
said.
dropped the link in the X chat as well. So if you want to, what'd you say?
Oh, go ahead.
So I just dropped the buy me a coffee in the X live chat as well. So if you're on your phone and you can't scan the QR code with your phone, you can just click the link I just dropped in the chat. Like I said, that is how you can support us, and also we will read your comment out live on screen. All right, let me get off this. There you go. That way we're not looking at a hall of mirrors.
Yeah,
okay.
No, I thought about it, and since we don't really have the truth on what transpired that day in the SUV, yeah, I think it'd be nice to hear from a third party.
Yeah, absolutely. I agree. Yeah, thank you very much. You're another one. It's like the third day I think I've seen you in here as well. So thank you for keep coming back each day. Obviously we'll be here tomorrow as well. You guys know that. Oh, by the way, well, actually, I don't know if I should announce it yet because there's a chance it might not happen, but I'll say it, and if it doesn't happen, it doesn't happen. But Jesse on Fire, tentatively, unless something else comes up, Jesse on Fire is going to be on the stream with us on Friday. So he's going to do the live stream with us Friday, the trial stream. So that'll be cool. That's the first time I've done a live stream with him. We've been wanting to do that for a while. I know a lot of you guys have asked us to do a stream together, and the timing just hasn't really worked out until now. But yeah, so he agreed to it. So Friday, unless something comes up, Friday, he'll be on the live stream. He'll be doing the preliminary hearing reaction stream with me.
Yeah, this will be, it's definitely, let's see.
They presented T-shirts, backpacks, hats, shoes, cars, no video with a face. Yeah, absolutely. They have zero evidence that it's actually Tyler Robinson. Zero evidence. They have no DNA that links Tyler Robinson. They have no actual images of Tyler Robinson. Even the car they claim is Tyler Robinson, there's no definitive way to say that's Tyler Robinson's car. They have nothing. And the text messages, we've already proven that the text messages, the actual text messages, they sound like they were written by, two cops in Israel, and they use like a language translation service, to translate, which made it sound really horrible. But that's what we have for the text messages. And then the Discord messages, we know for a fact the Discord messages are fake because they were authored after Tyler Robinson was already in custody in the Washington County Sheriff's Station. So he could not have authored them because he was already in custody and they already had taken his devices by that time. So they have nothing. They have no confession from him. They have no DNA. They have no videos of him. They have no fingerprints. They have no nothing. They have zero evidence that Tyler Robinson was ever there at all.
They barely even mentioned Tyler today.
Actually, yeah, you're right. And honestly, it shouldn't be about Tyler. It should be about Lance Twiggs because he's the one that they have all the most evidence for. Lance Twiggs is actually the ones that authored those messages, in my opinion. His is he's the only one that they can definitively say has DNA on any of those items. The screwdriver, the rifle, or the towel. He's the only one whose DNA is on that stuff. And we've thought, how easy would it be for Lance Twiggs to have set up his furry loving boyfriend? He lives with the guy. He has access to his computers. He has access to his car. He has access to his phone. He knows everything about him. It would be very easy for him to just fake all that stuff. And I don't know for sure whether Lance Twiggs was there that day at UVU or not, but I will say that it definitely was not Tyler Robinson. I could tell you for sure that was not, the person that they showed in those videos in the stairwell, either with the maroon shirt or the black shirt, neither one of them were Tyler Robinson. I know that much. And his family confirmed that. His family, when Billy went and talked to his family in the courtroom, during one of the previous hearings, they even said that, everything they said in the media is a complete lie. That never happened.
Well, and just to be clear,
in either. Not turn.
Yeah, I was going to say
just turn himself in.
Yeah, that's what I was getting ready to say. So basically, all they said today was that the mom and dad were interviewed, but it never said anything about them giving him up or, anything like that. Which is what the other side, the people that argue with us, they argue that his own family turned him in.
Exactly. And that's a complete lie. Like they say, that the Fed sloppers say that Tyler Robinson's parents recognized the gun that was shown in all the media. It was shown on the media. And they recognized that gun and knew it was Tyler's. So therefore they were suspicious of him. So they got with Tyler and, basically coerced him to turn himself in or whatever. And that's not true whatsoever. And we know that's not true. Besides the parents saying it's not true, we know it's not true because the gun that they showed in the media is not even the actual gun that they found. The gun that they shown was actually just a stock footage, that was leaked. Somebody leaked some stock image of a gun that honestly, it wasn't even the same gun Tyler Robinson had. So there's no way. How would the parents have recognized the gun on the media when that gun was not even the same gun that Tyler Robinson had, that their son had?
Right.
It's
and then
impossible.
what was the bullet they were just, it wasn't a 30-06. What was the bullet that they were describing that they randomly found?
Oh yeah, that's right. So yeah, they said they try to act like it's just no big deal or whatever. But yeah, they found I think they said it was 322. Was it a 322? Do you guys remember the bullet, the live bullet they found on the another roof on the oh shit, what's the name of it? I forget the name of the building, but they found the live bullet they found on another roof. Does anybody remember what caliber that was? 322. Yeah, that's what I thought it was. I thought they said it was a 322 round. Yeah, I think you're 220. No, 223. That's right, 223 or 226. One of the two. Yeah, you're right. Absolutely, you're right on that. Okay, so yeah, so that's important. All right. Why was that not? And that's another thing. We caught him in a lie because I forget who it was, but the agent that they had with SBI that testified yesterday, he claimed that they did not recover that round, that they lost that round because the defense asked him, well, do you have that round? Did you recover it? And he said, oh, no. And then they pressed him on it and they're like, well, it happens sometimes. Sometimes they just, they eject the rounds and then they can't find them or whatever. He specifically said something like that, to that effect. So, and then this guy today, I think Brian Davis was the one today, he said, oh no, we recovered that round. So which is it? Somebody's lying. Somebody just lied under oath in court. Either Brian Davis is lying when he said they recovered the round, or the officer that testified yesterday is lying when he said they didn't recover the round. But one of them's lying. So why is the defense not pointing that out? They should be objecting and getting that witness thrown out for lying, whichever one it is, because if you lie under oath, that's the reason for your testimony to be ejected. You're not a reliable witness,
Well, that's what I'm saying. Like, when you said the cat's already out of the bag, it's like the public has already seen the contrary. So, I mean, that's lying in and of itself by the defense.
Yep. And, but yeah, I want to know more about that. Like, okay, so they didn't treat that as a crime scene either. So they found a live round on another roof, which, by the way, that 223 or 226 caliber, by the way, I believe that, let me check. I'm pretty sure that's primarily used in long guns. I don't think that's one that's used often. Not that it can't be used in a short gun, but I'm pretty sure that's fired in only long guns. Let me do a little grokking real quick. 223 caliber.
That just kind of seems like a red herring. What do you think? That extra bullet?
I don't know. I think it's important though, because I don't, the shot did not come. There was a shot fired. I don't think it's a red herring. I think there was a shot fired that day for sure. There was definitely a shot fired that day, because the sound profile, we picked that up, but it wasn't fired at Charlie Kirk. It wasn't, they didn't kill Charlie with it. They only, the shot was only fired to mask the sound of the explosion, to make it sound like a gunshot. Okay, so it says, yeah, so it's an AR-15. So the 223 was developed for the AR-15 rifle. It's for long barrels. In short pistol barrels, it loses significant velocity, becomes very loud with heavy muzzle blast. So yeah, so it's long guns. They're made for long guns. They're made specifically for AR-15 in particular. So yeah, so they found a 223 caliber round on another roof from a long gun, which very well may have been the actual location where the shot was fired from, because there was a shot fired that day to mask the sound of the explosion and to make people think that it was an actual gunshot. But it wasn't
you
from,
think,
I'm pretty sure it
like,
was not from the Losi building.
Yeah, so his little sniper pad or whatever, it was kind of, that shot kind of came from a different direction to distract, essentially.
Oh, 100%. Yeah, 100%. No, there was no shot fired at all from the Losi roof at all. Whoever was up on the Losi roof, if that really is the surveillance video from that day, it was somebody else, and it was merely just to be a patsy, to make it look like that's what they were doing, but they didn't actually fire any rounds. If there was a round fired, I think it came from a different place. I think it came from a different rooftop, and especially because that's where the sound profile says. The sound profile does not match it coming from the Losi building. It matches it coming from, I think that's the roof that they're talking about, where they found that round. I think that's where they're saying, because it's to the east. Let me see if I can pull up a map of UVU real quick and take a look at this. Google Maps UVU. Okay, layers, we want to get, okay, satellite, that's what we want. Okay, so UVU. Hold on, somebody just pop in here? I heard a beep. No. Okay. That's weird. All right. Let me pull up this Google map real quick. Hold on. Share this tab instead. Okay, yeah. So they said they found the bullet over here on the applied engineering roof, which is over here. Right here, this roof. This is where they found this roof over here is where they found the 223 caliber live round. Losi Center roof is right on the other side over here. This is the Losi Center roof right here.
Okay.
and Charlie was over here. Obviously, he was right in the middle of this diamond thing here.
Right.
And the sound profile, when we did the sound profile or whatever, it showed that the sound of the bullet came from this side of the screen, this bottom part over here, down here.
He testified and said it was east. It's east.
Exactly. Yeah, and that's east of where Charlie was. And that's exactly where the sound profile says the actual shot came from. So that tracks. Oh, we got Billy here. Hey.
Hey, what's
hold on.
up?
Let me
Can you
move
hear me
this.
all right?
Yeah, we can hear you. Let me get my thing out of your way. That way I'm not blocking you, blocking your face. Give me a second.
Tyler Robinson's family. I'm gonna walk with my phone behind me. Here's all the photographers waiting for them.
How do I do this? Give me a second. Style. Widgets. Is it a widget? What is it? Media assets. More.
Media assets. We have Catherine Nestor here, rolling her luggage behind me. I can't see anything. It's so hot right now in Utah. We have Michael Burt. He's the older man back there. He's the one who did the Menendez brothers case.
Is it this one? Okay, yeah, it's this one. Let me move you over to this side. There we go. All right, now we're good.
Sorry, I just saw the.
All right, so
I saw the photographers freak.
So what's up?
Hey.
So how was it?
Let me get back to the shade over here so my phone doesn't overheat. It's so hot right now. It was really interesting in the beginning. I'm sure you guys have been live for 4 hours now. It got pretty boring there at the end.
Yeah. So okay, so I guess give us the tea from inside the courtroom. Like what did, who all was there? Were Charlie parents there today, or?
Yes, so actually I drew a little outline. It's so handwritten and not great, but if I can figure out how to turn my camera around on here, I actually can figure that out. Cool. So here we have Judge Graff. We have Tyler Robinson. This is all media people that got in. And then like all of the attorneys, like the prosecution, the defense. Here we have all of the Erica Kirk people. This is Erica Kirk. She's sitting over here. She was sitting right next to Charlie's mom. And then on the other side of Charlie's mom was Charlie's dad. Sorry, I just realized this is actually flipped from what you're seeing. And Stacy Sheridan was there. A few people that I didn't recognize that I just described were there. And then the second row behind them, it's more people that are with Erica Kirk. We had Jack Posobek. We had, okay, so I'm gonna just flip this back over and explain to you so you can get some facial with what I'm saying here. Graham Allen was there. Did not recognize him at first. I knew I recognized him. I was like, that guy looks really familiar. But I didn't know who he was. I was like, he's probably someone that I've seen on X, I don't know. But what I did know is this man is glaring at us. I'm sitting on like the row directly behind him, but across the way. So like he's on one side, I'm on the row behind him, way on the other side. Next to me is Brandy, next to Brandy is Teresa, and then next to Teresa is Elizabeth Lane. And he just would not stop glaring at us, rolling his eyes. Like I was literally like, who is this guy? I know I've never interacted with him, but I kept making eye contact with him because when I see someone from my peripheral that is like cranking their neck, I'm gonna look over, and I was the one making eye contact with him, and he would literally like shake his head and roll his eyes really hard, and I was like, this guy, I don't know even who he is, but he clearly knows who I am.
Yeah, that's wild. He's you know, honestly, he's been one of the worst ones out there, you know, screaming that, you know, Candace is demonic, we're all demonic and everything, you know.
I have never seen a more bitter person, honestly. And Jack Sobiek, I think I'm saying that correctly. He was actually pretty friendly with all of us, and I don't mean like buddy, but I mean he was, you know, civil. And Graham Allen, on the other hand, oh my gosh, like, he's acting like I killed his dog, honestly.
Yeah, that's wild. Did Erica leave early again, or did she stay the whole time?
She did not leave early. I honestly, with her being in the front row and me being in the third row, I only even caught a glimpse of her face like once or twice, and it was in between recess, or like in between sessions, like walking out for recess, walking back in after recess. Like Graham and a few others. Oh, Brandon Tatum was there. I know we know who that is.
Yeah, Talmud Tatum.
Yeah, he was there. They were like guarding the bathroom when she was in the bathroom, which is totally understandable. Honestly, I'm not like talking shit on that. If I was as like prominent of a figure as she was, I would want people to guard the bathroom if I was in there too. But I don't really have anything to say about Erica herself. She did get pretty emotional towards the end. And I'm
oh
not
my
sure.
God, really?
She like how you.
She had the tissue.
That is exactly like to the T. Like take her out of that out of any sad video that you've seen of her and put her in real life. That is exactly how she is. Like she looked like she was really scared the whole time. Even like when I did see her on recess, like she didn't want to like look at anyone, which I thought was interesting. But yeah, she never made eye contact. But I did like catch a glimpse of her here and there, and she was really minding her own business, crying towards the end. She was hugging the woman to her right, which I can only assume was maybe her sister. I did not. So Charlie's mom is to her left.
It wasn't Stacy Sheridan?
No, it wasn't Stacy Sheridan. Stacy Sheridan was sitting, I believe it was 3 people away from her. 1, 2, 3. She was 4 people away from her.
I wonder who she was hugging then. That's weird. But yeah, that definitely surprises me that.
I think it was her sister.
Her sister. Okay.
They had some similarities in their, facial stuff. Let me see here.
I can't believe that she. Well, I guess I can believe it, but it figures that she would be, trying to play all that emotional crap in the courtroom.
What made it weird to me was like the timing of the crying, and I was trying to kind of piece it together because I'm always trying to play devil's advocate. I don't want to be like, oh, she was crying, I was literally just like, why? Like, okay, yes, obviously, like when you think about everything, there's reasons, but it was like really weird timing because it was the most boring. You guys watched it, right? You were there the whole time?
Yeah, towards the end, you're talking about she was crying when they were discussing about Lance Twig's testimony and whether to keep that part in or out or whatever?
Yes. That's like she started crying, and I don't mean like sniffling and like wiping a tear. I mean, she was like I could see the back of her, and she was like shaking, and the woman who I believe to be her sister was like rubbing her, hugging her constantly. At one point, Charlie's mom came in from the other side and was also comforting her. Yeah, it was just like an interesting time for the crying, I guess, in my opinion.
That woman is so performative, man. And they were trying to get their way, obviously, which, I actually agree with what his lawyer was saying. Her lawyer, when her lawyer came in there about, it needs to all be public because Otherwise, it will create a distrust with the judicial system. So I agree with what her lawyer was saying, but I think all those emotional crocodile tears, I think that was just try to get the judge to rule the way she wanted the judge to rule. Emotional. Once again, she's using emotional blackmail.
Yeah. You know what? I also was pleasantly surprised with her lawyer. I was like, wow, they want what we want.
Yeah.
Yeah, maybe.
By the way, that's the same lawyer that sent me a cease and desist.
That's the same guy?
Yep.
Jeffrey.
The last one I got was from him. Yeah.
Yeah. Jeffrey, Nama.
Where's Frank? Colin, where's Frank Carney? Why isn't Frank Carney in there?
I don't know. Why do they have a lawyer on payroll, a full-time lawyer, if he's not the one that's doing all the cease and desist and stuff? It's very weird.
Because he's not licensed. Do you know who Frank Carney is, Billy?
I don't. I was gonna ask. Sorry, making sure.
He's the head of their legal. He's the head of their legal team, but I'm curious as to why he's not in there observing.
Are you sure he wasn't? Because there's a lot of people that I didn't recognize that I couldn't put a name to.
He could. Can you pull up a picture of him, Colin?
Yeah, sure.
Well, I also.
Let me see if I can find one.
Oh,
let me look. I'm gonna look too.
Frank Carney, TP, USA.
I'm keeping an eye out for the Robinson family because I don't believe they've exited yet. So if I randomly am like,
really?
Oh, coming. Yeah. I think they're,
yeah.
All the news outlets are still here. I believe that's who they're waiting for, but they may have exited through the back entrance.
Why is it not? Hold on.
Did
This is him, right?
This is Charles McClintock Wilson. This is just a live stream that I'm on right now. It's Project Constitution, but I was wondering, did the Robinsons leave yet?
That's him, isn't it?
So, I haven't seen him.
Damn it! Why does it keep doing that?
Are you leaving?
I'm looking too.
It's not letting me zoom in for some reason.
You have it pulled up here? Oh, I don't see it yet. I can look it up.
C-A-R-N-I or C-A-R-N-N-Y?
It's I as in igloo.
Oh, okay. That's probably why I wasn't getting it.
Because I had
Frank
no
Carney.
clue. I had no clue who that Jeffrey
Is
guy
this
was.
him? Oh, I'm not sharing it.
I can't see it.
Hold on. Let me share it. Yeah, I wasn't sharing it.
This
Let me
is
share it.
him.
Give me a second.
That's him.
He was there. He was sitting right
Okay,
next
yeah,
to
that's
Jeffrey.
who I had.
Whoa.
Yeah.
I knew
okay,
it.
so he was there.
Yeah, and those two, I was like,
Interesting.
I was like, who are they? Because they were sitting next to, it was like those two guys, and I was like, I have no clue who they are. I wrote down how to try to remember their faces. The Jeffrey guy, the one who came up and spoke on behalf of the Kirks, I wrote him down as some actor lookalike. Like, he has a very unique looking face. Like, I don't know, but yeah, they're still not coming out if they haven't already. But I had no clue who those two guys were, and then it was Brandon Tatum, Jack, and then what's his face? Ugh, Mr. Angry.
Colin.
Yeah, for real.
I've noticed Brandon Tatum, he made a big deal. He's like, I'm going to be there in the courtroom and I'm going to report everything. And I'm like, he hasn't had anything to report. Nothing positive.
Well, what's crazy is I think I haven't been on X in a little while. I just got back on X for the first time in over a month today. But according to, Elizabeth, Brandy, and Teresa, everyone that I was with today, I guess they've been saying since nobody's shown up early enough to get in any of the past 2 days until today, I guess there was a rumor going around on X, maybe you guys have seen it, that like they were trying to say Elizabeth Lane is banned from the courts because of this or that, but no, not banned, definitely not banned. Just you got to show up really early. We showed up at 5 a.m.
That's funny.
You know, we were sitting there until we finally got our wristbands at noon. That's 7 hours that we were just hanging out there.
Yeah, that's crazy. I'm glad you got there early enough to do it. And you said the only reason you were is because you actually didn't know that they were doing a late day. You thought it was going to start regular time, right?
I thought it was a 9 or 10 a.m. one, and I was like, yeah, 5 a.m. is good enough. If it had been, it would not have been early enough. And if I were to tomorrow's 9 a.m. again, if I show up at 5 a.m., I won't be making it. There's people saying that like 3 a.m. they're guessing is going to be like about middle of the road. Like, so if 14 people are allowed, then 7 people will have shown up around 3 a.m. So I definitely don't want to be first again. I wasn't first today, but I don't want to be close to being first either, because I would prefer to get some rest, but I'm not gonna risk it.
Why don't you hire you could probably find somebody just to hold your line out there for you. You know, go pay a homeless person or something, you know, give them like $50 to go camp out there in line for you.
That is actually, that's a business mindset right there. There you go. That's an idea that I had not thought of.
And all parties win that are involved.
The Karen Reed trial. Yeah, exactly. The Karen Reed trial, that's what they did in the Karen Reed trial, because it was similar things for that.
Interesting. Huh. Yeah, I won't be doing that just because I feel kind of bad, even if I'm paying someone to do that, but also I'm probably not going to pay anyone to do that. I'm not sure who's walking out right now. Yeah, I think.
Were you able to talk to anybody? Were you?
No, not really.
You said somebody.
They made, this is like very, very strict compared to, you know, the
last time you were there, right?
Yeah, all of the motion hearings that we've been to versus this one, it's like night and day, the difference, because, you know, in the motion hearings, we were allowed to have laptops in the room. We could have our phone in the room. We just couldn't be on our phone, but people would still get on their phone because they were just that relaxed about it. And this one, it's like you're walking through metal detector. You cannot have anything but your car keys, pen, and a notepad. Like, I even asked like 3 different guys. I was like, can I bring some nicotine pouches? And they were like, no, all of them. I was waiting to see if like they just didn't know the answer, but no, it was a strict no. And Teresa got in trouble, not like in trouble, but got kind of like scolded a little bit just for turning around and like looking behind her, because the Robinsons were seated at behind like the public, because they always separate the each party. So they were behind us, and I guess Teresa like turned around. I don't even know if she was going to look at them, but one of the security officers came and scolded her. He was like, if you keep turning around, I'm going to get you out of here. And I literally was like,
really? That's wild.
Because he pops his head between the 2 of our shoulders. And I'm like, I'm scared to even look at him at that point. And it was so like, it was in my head the whole time, because before that, I'm just, I'm not like staring at anyone, but I'm looking around like normal. And once he said that, I was like, I'm not looking back. Do not look behind you. And it was so prominent in my brain that even when I left, like we walked out of the courtroom, I'm like walking towards the elevators, and I like went to turn around, and I was like, no, I can't do that. But I could turn around at that point. But it was like, it was so ingrained that I was like afraid to turn around still.
Yeah, that's crazy. I mean, you can't even look at them. Like, that's wild to me. I mean, I get like not bothering them, like not talking to them, but for them to tell you can't even look at them, that's kind of crazy.
Yeah, it was weird. He was like pretty stern about it too.
Especially because the first time, like in the motion hearings, you actually had a chance to talk to Tyler Robinson's family and stuff during the one hearing,
Yeah, I tried to, make eye contact with that family member just to smile, but there wasn't even an opportunity. Like every time I was looking at her, she was like looking down. I just wanted to like throw a smile up and be like, hey, we know each other, you know? But
yeah,
didn't work out that way. But there's 2 more days still, so we'll see. But the freaking the Graham Allen thing, that was like when I finally, because I walked out of during the first recess.
that guy's a douchebag.
I guess Brandy and Teresa didn't realize like the extent, or maybe even at all, that this man was glaring at us so heavily and rolling his eyes, and it was so odd to see a grown man do those things that I don't even do. Anyway, as a 27-year-old girl, and he's like, but I still didn't know who he was at that point. So we're on recess, and I'm like, did you guys, like, who is that guy? Why does he, like, he's really mad. He's angry. Like, we've offended him. And they didn't even know what I was talking about. And I'm like asking Elizabeth Lane, and she's like, that's Graham Allen. And I'm like, oh, still, I've never even interacted with that guy, not even on social media. I've seen his tweets, and I've thought to myself, wow, that's really dumb, but I've never said it to him.
Yeah, he's a douchebag. Him and I have gotten into it a couple times. You know, he's a jerk. But you know, for him to take it, that's really weird though. That he would, you know, somebody like you, like he's never even interacted with you. For him to be that personal with you and that, you know, have that much animosity is just crazy to me.
Maybe he was hallucinating. Maybe when he looked at me, he saw you.
Yeah, it's hard to tell the difference. You know, I'm that's either a compliment for me or a you know, a burn on you. Yeah.
Yeah, there wasn't. I'm trying to think about like the inside the courtroom stuff that you guys wouldn't have gotten to see. I mean, I've told you most of the people that I was aware of with their names, with who was there.
Somebody in the chat did want to ask me, what did they do during the basically like hour-long break? At the end, towards the end, they were only supposed to take like a 15-minute break, and it ended up being like an hour-long break.
So,
do you know what happened during that?
So when they tell us 15 minutes, we can't risk it. We can't be like, they might take longer. And this happened during multiple of the motion hearings too, where they would say, you know, 10-minute recess, 30-minute recess, and then it would end up being double or sometimes even triple the time. So we came outside, we went in, got some water. I texted you really quick. I texted you like with a bunch of misspellings because we only had, you know, like 15 or 20 minutes in our minds. And I'm like, Graham Allen's really mean. I texted you that, something along those lines.
Yeah.
So we run back inside, we're like sweating, and then we just sit there for the next 40 minutes, and we're just like whispering to each other. It's never loud in the courtroom. So everyone's just sitting there whispering for like 40 minutes. It's really boring. And then Graf comes on, and he's like, sometimes you have to take time to save time. I'm like, and guess what? No time was saved. We literally didn't do anything after that.
Yeah, today was kind of a wash. There really wasn't much of anything discussed today. I mean, we did get, you know, they released a video of Tyler Robinson, or who they say is Tyler Robinson, in the Washington County Sheriff's Office. But the picture, I don't know if you saw the video they released of him, but the video they released of him, he doesn't even have his face towards the camera. He has his head down away from the camera. So even in that, you can't see that it's really him.
Yeah.
Which is kind of really, really weird. And and with the other stuff, like like them arguing about the text messages and everything, like they're already out. Like I kind of get what, you know, I do get what defense is saying. Like you don't want somebody, you know, the confession to be out there. But at the same time, it's already out there. The cat's already out of the bag. Like they've already done that. It's already in the media. The public already had it. There really is no point. There's no sense at this point of trying to hide it any further. You know?
Yeah, I was 100% like I said, pleasantly surprised by Erica's lawyer there. I was like, yeah, I totally agree with everything that he just said. But in terms of the Tyler Robinson video of him, you know, in the St. George office, I will be honest, there wasn't any part of me that was like, that doesn't look like Tyler Robinson. Whereas, you know, other instances, and I'm sure we're on the same page here, like the stairwell photo. For me, in my mind, that does not look like Tyler Robinson at all. But that I didn't get that same feeling from this one.
No, I'm not denying. I'm not denying that that it's not Tyler Robinson that turned himself in the Washington County Sheriff's Office. I'm just saying they don't even have video of that. They have zero proof showing Tyler Robinson whatsoever. They have nothing at all.
Yeah. One thing that I did write down that I wrote a big WTF with was towards the very beginning, and maybe you guys caught this too since you were listening. This, like I said, this isn't anything like unique to me having been in there because everyone heard it. But when Brian Davis was on, you know, the first witness that they brought on, he's the SBI guy. He's been there for 27 years. He's talking about who was interviewing who he interviewed. And do you remember when he was like, oh, I may have misspoke? Because he's like, oh, wait, no, I interviewed me and, who is he? Him and Folger interviewed someone. And he's like, oh, I may have misspoke. Actually, Cox and Holt, I can not even read my own handwriting. Terry and Smith, FBI agents. He just got it so backwards, and I would not have caught that had I only been listening, because I'm taking like vicious notes as they're talking.
Yeah.
And I wrote down like the first thing he said was Matt Robinson, Tyler Robinson's dad, was interviewed by Terry and Smith, and that Amber Jones, the mom, was interviewed by Holden and Cox. And he was like, what about the friend? What about the family friend, Mike Mitchell? And he was like, oh, that guy was interviewed by some other agents. Literally in quotation marks, and I put question marks around it because I was like, some other agents? That's his answer? Seriously?
Some other.
And then he goes back and switches it all up, and he's like, oh, wait, no. Holden and Cox interviewed Matt Robinson. I interviewed the mom, and Terry and Smith interviewed the friend. How do you forget who you interviewed? Well, it's not that he necessarily forgot, but he misspoke on something that I definitely wouldn't have misspoke on. Like, if I'm interviewing, that's a crazy... I don't know. He misspoke on
something like that. Exactly. Something like that. That's not something that you would forget. I mean, you'd know who it was you interviewed. You may not remember exactly what they said, but you'd know who you interviewed, especially in something this high profile, you know?
Yeah, absolutely. That one, I put big, like, after I took all those notes and I was like listening, and I'm like, wait, what? Scratching things out, rewriting my notes. I'm glad I left my scratches instead of just erasing, because I was like, I know what I wrote down was correct initially, and like, we still have the audio, we can go back and listen, but how do you get wrong who you interviewed? How do you say some other agents? Oh wait, no, I got that. Like, what? That was so, I put a big WTF on that. I was like, I gotta talk about that.
Exactly. The other thing I noticed that was really important was when Brian, I think it was Brian Davis that said it, but when he had said that they found that it was a .223 caliber round that they found on the applied engineering building or whatever. That was kind of important to me as well, because honestly, somebody's lying, and the defense didn't catch it. The defense should have immediately either objected there. And here's the thing, because the person that testified yesterday, remember they testified about that yesterday, and we're like, oh, it's no big deal. And they originally, the person that testified, the officer that testified yesterday, said that they did not recover that round. Because they asked, well, did you pick up the round? Did you recover it? And they said, no, we don't know what happened to it, or whatever, something of that sort.
Yeah.
And then Brian Davis today said they did recover that round. So which is it? Somebody's lying.
And not only that, but did you hear when she was like, is there a line of sight from that area? And they're like, no line of sight from Charlie's tent. So logically thinking, why would anybody who's planning this leave a bullet where there's no line of sight? It just makes zero sense.
my theory from the beginning is there was definitely a shot fired. I think there was a shot fired that day. I think Charlie was killed with the exploding mic for sure, but I think there was also a shot fired, and the shot was fired specifically to mask the sound of the explosion, to make it look like a gunshot, to make people think it was a gunshot. But I don't think that shot came from the Losi building. I think it came from that side east of where Charlie is, like where he's talking about, like where they found that round on the applied engineering building or whatever. So when I heard that they found another round on a roof, that raised my antennas up yesterday. And then when he said that it was the applied engineering building today, that just like sent the alarm bells like going in big time for me, because like when they did the sound profile said it was like from that area is where the round came from that side of Charlie.
Yep.
You know, from where the gunshot came from.
Well,
so, yeah.
Everything that you just said brings me to something that I can't believe I didn't even start with. But this is a conversation that I had before, you know, when we're waiting for hours and hours and I'm just chatting with other people who are standing in line waiting. This is a crazy thing, like a crazy conversation that I had with this woman. And I know this woman's name. I've seen her at all of the motion hearings that I've been to. She's been going to everything. And I finally just, you know, when you're sitting there for 7 hours, you really get to know someone. So I can't believe I didn't know this about her before, but her granddaughter was at the event. And I'm going to try to tell you this story in the way that she told it to me, because it is absolutely insane. And it is hearsay. I'll tell you that. It's absolutely hearsay. What I will say is that I do really like this woman. She's a little bit standoffish, which makes me think that she has no agenda, because she's been standoffish the entire, I've spoken to her every time I've been here, and she's a little bit shy. She's a little bit standoffish. She doesn't have like any secret agenda, in my opinion, that she's been trying to do. So she said her granddaughter didn't really mean to go to the Charlie Kirk event, but she just attends UVU. On September 10th, she had planned to get lunch with her grandma, the woman that I'm friends with. And she texts her grandma and she says, "Hey, I'm going to be a little bit late to lunch. I'm watching a little bit of this Charlie Kirk guy and then I'll be there. I'm just going to stay for like 5 minutes or so," right? So she just watches a little bit. She starts leaving through the Hall of Flags. Now, if you remember where the Hall of Flags is, it's like, it has the clearest view of the Losi Center. It's up above. It's up above everything.
Yeah, that was behind Charlie.
Yeah, exactly. So she's like behind the tent, up above, straight on with the Losi Center. And she's taking some photos. She sees everyone duck down, and this is from the grandma's perspective. So it's really like second person, third person story here. But she sees everyone duck down and she doesn't have any clue what's going on. And the grandma said that she thought that everyone had been told to sit. And she's like, "Oh, cool." She goes to take a photo. As she takes the photo, everyone starts scattering. And her grandma has seen this photo but doesn't have the photo. And she's like, "There is not anybody on the Losi Center roof." Isn't that crazy? And like I said, total hearsay. So it's like, it's really hard. But I was like, okay, miss, you know, I don't really want to like dox her or anything. She's very shy, but it's like, why don't you ask her for the photo? And she's like, well, everyone in my she's from Provo. Her entire family's from Provo. If there's anything about Provo people, they all believe in everything that the media says. I've learned, with a very small exception. And so some more context to this woman is like, she never shows up with anybody. She always shows up on her own, and she doesn't really ever talk about this with anybody, because if she even brings up anything, they all think that she's crazy. Like, she tried to talk her family out of getting the COVID vaccine way back when, and it kind of like hurt her relationship with some of her family members. So she does not talk to her family members about this stuff. And she made some comment when I was like, "Why don't you get this photo? Like, you could send it into And to the defense, you could do so much with it. And she's an older woman. She's not a content creator. I wasn't like, hey, you should become a content creator. It'd be super cool if she did, but she doesn't even have the photo. I was like, you should get it. And she's like, I just don't want to hurt my relationship with my granddaughter. And so I don't know the full context of that. And maybe they're not that close, but she did say she saw the photo. Another comment that she made was like, my granddaughter doesn't even know what she has. And if what she's saying is true, she's correct. Her granddaughter does not know what she has on her phone. Insane to have taken a picture at that exact moment, at that exact timestamp. Pelosi Center is in full view. You're straight on with it. So even if the man was laying down, you would still freaking see him.
Oh, absolutely. 100%. And honestly, I don't think, even the surveillance video that they showed us that day of somebody, that they showed yesterday of somebody supposedly, running up there and everything on the roof. I still don't think that was the same day.
Yeah.
Or if it was the same day, I don't think it was the same time. I think it was either before or later or something. I don't think it was when the shot, from when Charlie's event was going on. I really don't. Because nobody saw anything, and there were a lot of videos pointed that direction. Like, I've gone through every single video that I can find that is pointed that direction during the event, and there's nothing. You can't see anybody up there.
Yeah. She is on the same. She's like, it's either AI or it was not on the same day. She said that exact same thing. And with her having told me that story, there's only 3 possibilities. One, she's lying. That one I'm gonna put at the very bottom because I really like this woman. I trust her.
I doubt it.
She's very kind. She's very cool, very shy. Number 2, she missaw. There was somebody on the roof, and she just saw the photo one time, and she just happened to not see. Number 3, those exactly that. It's fake or not that same day.
We've already got them faking evidence with the Discord messages, because we know that the Discord messages were authored after Tyler Robinson was already in custody in the Washington County detention center, not detention center, but sheriff's office. He was already in Washington County Sheriff's Office detained, and they had his devices. He did not have access to his devices. So how could he have authored those text messages? Not the text message, but the Discord messages.
I'm very, very excited and more like just anxious to see what they do show. I hope they show more than they don't, but I'm ready to see those Discord messages, and I'm ready for them to talk about it. And I really hope that's tomorrow.
Yeah, well, from what they said is they're not going to show any of them at all. I mean, that's basically the conclusion they came to at the end of court, was that we're not allowed to see any of that. That they're going to block the audience from block anybody in the court and block any of us at home from being able to see any of that.
Did they fully came to that conclusion?
Yeah.
Oh my gosh, I'm so tired. I feel like an idiot
when he was talking about the redactions, that's what he was saying. He was, that's the second redaction that he made. The first redaction was just, I think, like privacy information. But the second big redaction from like 6 minutes all the way to like 28 minutes or whatever, that redaction specifically was for all the Discord messages and text messages that we're not allowed to see now.
Didn't Novak at the very end, like, wasn't the ending of it him asking for 5 slides, and Graf was like,
that was something different.
Okay. Yeah, see, I'm on 1 hour of sleep. This is why you need sleep before long court hearings.
At least you made it today. That's all I can say. That's a good thing. At least you made it today, because I know you were really upset the last 2 days you tried to get in and weren't able to. So I'm definitely very, very happy you made it today.
Yeah, very upset. It was really cool hanging out with everyone too. It was honestly like, it wasn't that terrible waiting for 7 hours, since got to chat with people and hang out with Teresa, Brandy, and Elizabeth. But Yeah, I think I'm gonna head back to my car. The reason I've been hiding in the shade is because it's like 97 degrees, and if I even stand out there, my phone goes into like, you cannot use your phone mode because it's too hot.
Yeah, I got you. All right. Well, thank you for coming on and joining us. And hopefully we'll have a good time. I know you and me still are set to go to, whenever they do finally have this hearing that in the Candace Owens case in Delaware, you and me are scheduled to go to that. So.
Gosh, yeah. I want to go to every like major hearing like this now. I really want to go to, sorry, I know I just said I gotta go, but the FBI director's little tiny daughter, girlfriend, whatever, Alexis Wilkins.
Uh-huh.
You know how she's suing 3 individuals for $5 million, one of those individuals being Sam Parker?
Yeah.
Because they called her a honeypot, and one of the people, I'm not sure if it's Sam, one of those 3 never even said those words, but she's still suing them.
Yeah, that's Sam. That's the thing. Sam never even called her a honeypot at all, and he is getting sued somehow. Yeah, but I've called her a honeypot about 20 or 30 times to her face, and she hadn't sued me. So that, I don't get it.
You got to pick and choose who you think has $5 million, right? If you really want $15 million, who's going to give it to you?
I guess that's it, Dude, I'm not worth their time.
Was talking to Sam earlier today, and so all 3 of those people, Elijah Schaefer, the other guy whose name I can't remember, and Sam, have all filed to dismiss on certain grounds. Elijah and the other guy have gotten theirs denied. So there will be a trial for both of those 2. I'm not sure which states they live in, so I'm not sure where the trials will be. But Sam's motion to dismiss has not been denied yet, although he has a strong feeling that it will be. So there will likely be a trial at some point. I would love to go to those. I just want to go all over to all the trials, honestly.
Yeah, it'd be pretty cool. It's definitely... there's a market in it, and there's a niche for doing that. You could definitely build a good audience, you doing that. There's a lot of people that would love to, that would follow you specifically for that kind of content. I think that'd be a good niche to get into.
Hell, I would follow myself. It's so much fun. It's so much fun.
Yeah, I'd love to do it. If I wasn't disabled, I'd be all over the place at these things myself, man, personally. I'd love to be there myself.
You really should have been here.
Yeah, I am going to try to go to the actual trial. So fingers crossed. Yeah, I would. Yeah, I'm kind of bummed. I figured this preliminary hearing wasn't going to be very much, so I didn't try to go to it. But I'm bummed out that I didn't. I kind of wish I would have. But I think I'm going to go to the actual trial though.
Yeah. Blake Bednar's is like across the street in a hotel somewhere. Kelly Raybon's here as well. And they just like, when I called Kelly this morning at like 6:30 a.m., I was like, there's 4 spots left. Called Blake, he didn't answer. I'm trying to get them here. Blake had gotten into a one-wheel accident, so he's like healing from that. And then Kelly was like, already there's only 4 spots left. It's 6:30 in the morning. I'm not going to go to this one. So it's like, it's a sleepless week. Sleepless in Salt Lake City.
Yeah, I'm telling you, honestly, if you do turn it into like a profession, if it's something you do like long term, like going to a bunch of trials and stuff, you definitely gotta bring somebody with you that you pay. Either that or hire somebody locally to be a line sitter for you. Yeah,
that is a good point, honestly, and a really great idea. Also, speaking of turning this into something, do you mind, Colin, am I allowed to say your name?
Yeah, you're fine. Absolutely. People know me.
Okay, cool. Do you mind if I take this clip and post it on my personal YouTube channel, like what I've joined in on?
Yeah, absolutely.
Cool.
Absolutely.
I love that because that's so easy for me. I feel like I didn't even do any work, and that you're the best for not being offended by that. Thank you.
No, you're more than welcome to. Absolutely. And I've already directed all 3 days. I've directed people to go to your channel. Doing it again today. Like I said, now noticing on YouTube. That's her new channel. Make sure you go follow her. Also on X at Billy Webb with 3 B's, BBB. Billy Webb, BBB.
BB was taken.
So, yeah, follow her. She's an excellent investigative journalist. She's become a good friend of mine, and she does good work. And I thank her. Like she didn't have to come on here today, so I appreciate her coming on and giving us some information. And
Yeah, it's fun to talk.
yeah.
Kelvia, it's nice to meet you also.
Yeah. By the way, Kelvia, I don't know if you know who she is. Yeah, I don't know if you know who she is or not, but Kelvia is actually one of the former Turning Point employees that was fired. She's the only Turning Point Action employee that was fired during that mass wave of firing. She worked directly with Tyler Boyer.
Dude, I was like, I recognize you so hard, and I don't want to be like, I recognize you, but who are you again? That's why I
No, it's all good. Yeah, follow me. I think I added you, or I followed you.
Yeah, I'll find you. I'll get you.
Are you gonna try to do any more of the days, or is this the only one you're gonna do, or?
So I think Friday is going to be really up in the air because it's the last day, and I think a lot of people that showed up too late on other days or were busy trying to catch up on sleep, I think that everyone's going to come flooding in on Friday, so I feel like I need to be here tomorrow, and I still want to try to make it on Friday, but both days, tomorrow and Friday, are 9 a.m.s, and so I think I'm going to show up around 2 or 3 a.m. tomorrow, but I think anyone who wants to actually get in on the last day, which is Friday, it's going to be like a midnight type of ordeal, I think. So we'll see if I'm somehow able to sleep like right now and not go on 2 days of no sleep, then I definitely want to make it tomorrow. But yeah, I'll if you guys are on live again tomorrow, I'll hop on after the trial.
Right.
We'll do something similar.
Yeah, definitely. That's what I was getting at anyway. Because we're going to be doing every day they do it. We're going to do it. Honestly, if they extend it, it's looking like they might even have to extend it to Monday because they didn't get done anything that they thought they'd get done today. So we'll see.
I've had that thought too, which would be really interesting. But I did definitely have that thought. That would be great if they did that because then I wouldn't feel so pressured.
Yep, for sure. But yeah, so. If you get in there, for sure, you're more than welcome to come in here. We'd love to have you come on afterwards. I'll be back. Convict to Conservative will be with me tomorrow. And then Jesse on Fire is going to be with me on Friday doing the live stream. So
nice. You got your lineup. You got a great lineup.
Oh, yeah, absolutely.
Cool.
So thanks for joining me.
Yeah.
Get some rest.
Sorry.
Yeah, get some rest.
Get some rest.
Definitely.
Oh yeah. I was falling asleep sitting up in the courtroom. Anyway. All right. I'll talk to you guys later. Thanks so much for having me on.
All right. Thanks again.
Peace.
Bye, Billy.
Yeah, that's awesome
Well,
that you actually
cool.
have someone there. Yeah, someone there in the flesh.
Yep. What's up, Convict? What's up, brother? Good to see you, man. Yeah, so tomorrow, he'll be with us again tomorrow. And Kelvia, like I said, go follow her at Conservative KFC. Be sure to follow her. Her and I, she's actually putting out a lot of cool stuff lately. Especially, she's got a lot of cool memes and stuff she's been putting out. So if you're a meme person, she's definitely a person. But her and I got some big stories we're working on that are going to be coming out shortly anyway in the next few weeks. So pay attention to that. Yeah. Oh, actually, real quick, let me just check the buy me a coffee and see if anybody has sent any in before we get off one more time. Okay, yeah, we got one. So let me show it on screen for him. That way I want to make sure I'm doing everybody justice here. Share screen.
I'm gonna look at your QR code.
Sure, be my guest. Okay, so there it is right there. All right, so here, this is I got it on the screen, by the way, if you just want to look at it there.
Oh, yeah.
Yeah, this is it right here. Anyway, so we got Medusa, USI. Thanks for day 3 of Tyler Robbins' preliminary hearing. And thank you very much. I appreciate it. Medusa is another one that's been with us for a while now. He or she's been with us all 3 days. So thank you. I recognize your name as well. So definitely thank you for joining us, and thank you for the support. We definitely appreciate it. And yeah, so on that note, guys, I think we are done for the day. Like I said, thank you again for joining me. I think it was we had a good short trial. It wasn't that long a trial today. It was manageable. I definitely like these short days longer than these 10-hour shifts. That's for sure. You picked a good day to co-host with me. That's for sure.
I know. It was chill. It was aggravating to watch a little bit, but it's chill.
Yeah. Honestly, there's so many times that I just want to scream at the screen because I'm just so aggravated with either the judge or the defense. And not so much the prosecution, because I expect them to be assholes. I expect them to do everything cruddy. But, the defense and the prosecution have really disappointed me the most. I mean, not the defense and prosecution. The defense and the judge have really disappointed me the most.
Yeah, I mean, I'm telling you right now, if that defense team had you and Candace on, Baron, if it had any of you all on there, it would be so over. It would be so over.
Yeah, they don't have any evidence. I mean, honestly, they really, that's the thing is, if we had a judge that wasn't corrupt and we had a defense attorney that was actually doing their job and working for Tyler, it should have been thrown out already. It would have never got to this point at all. They do not have any evidence. There's nothing that they do not have probable cause to charge him with anything at this point.
Nope. If that's what they got, I mean, in a preliminary hearing, do you give everything you got? I mean, you have to present, there's enough evidence.
No. I mean, I'm sure they got more stuff, but as far as like the big stuff that they have, like of course they got like a bunch of witness testimonies and all that stuff, but like the video evidence and the text messages and all that stuff, like they presented that already. Like that's all they got. Like what they showed today is basically what they got,
That's
they would definitely show all of that because they want to make sure they get the charges. If they don't show enough to get the charge, to get the probable cause, then the case gets thrown out and there's no, then they don't even get to go to trial.
Yep.
So they would have to show enough to get it.
I mean, like I said, you can trim the fat off a steak, but when you just keep cutting it up, you're not going to have anything else. So it's going to be interesting.
Yeah, I mean, that's the thing is that a lot of the stuff the prosecution has put out now and they're trying to say is evidence has actually done the opposite. It's actually further proved that Tyler is actually innocent. For the DNA, for example, that all that proved, they try to say they got Tyler's DNA when they don't. They have Lance Twiggs' DNA, and Tyler shouldn't even have been listed as a possible contributor on there.
No, but like I said, they had to put his name in there to connect him to that evidence. Mm-hmm. That's why they did it. But absolutely. Yeah, it's going to be it's going to be interesting for sure. We have to pay homage to people like you and Baron and Candace, and because before the audiences could be fooled by this whole court process and like all the semantics and stuff they're getting caught up on, you all kind of prepared people that this is what was going to happen. We know based off all the evidence that you all have gathered and uncovered, it definitely prepped people, and that's what they didn't want. And that's why they have a problem with people like you. And probably why you have 3 cease and desist letters, but because you specifically have caused a stink. You've stirred up some stuff. But yeah, no, thank goodness for you all to kind of educate people along the way. What they wanted was the Fed slop, the main narrative. They wanted everybody to be in the dark until the trial. So you guys are the light.
We are. We're going to keep shining a light. But you're absolutely right. They wanted to just blow over. They wanted everybody. Charlie. They wanted to kill Charlie. They wanted to capitalize on his death. And take everybody's emotions and harness that emotion into the midterms and to supporting the Republican Party and make sure they get lots of donations for a turning point in the process, and then they wanted it to go away. They wanted all of us to forget about it until the trial started, and then they just railroad this guy. And that's what they wanted. They wanted us all to forget about it. Tyler Robinson's guilty. We already know he's guilty. That's the end of it. And then the trial comes, and that's it. They just, quietly prosecute this guy, and there's their patsy, and all's well that ends well, And we stuck a monkey wrench in the works. We proved that that's not true. We've been banging the drum from the top of our, screaming at the top of our lungs and banging the drum this whole time that they're wrong and pointing out all the evidence that to the contrary. And no, they don't like that. They don't like that because we've kept this alive. What is it, like 10 months now or 11 months now, into this? We've kept Charlie's name alive. We've kept this trial alive this whole time.
Yeah, ironically, you all are the ones keeping his legacy alive, even though they project and say that we're ruining his legacy. It's all projection, but no.
Yeah.
No, and I tell you one thing, Colin, I really think if they try to play us and, depending on how this case goes, we should take it all the way to the Supreme Court. Depending on what they do to it, depending on,
It might. We can't be the ones to do that. Obviously, it would have to be Tyler Robinson's legal team. But
right,
I hope if he doesn't win, if they do find him guilty, I certainly hope that they appeal that ruling and take it all the way as far as it's got to go to the Supreme Court or whatever.
Yeah, because you and I both know this case. I mean, it's a big deal. It would be worth their time. It concerns the entire nation. I mean, if people really knew what's going on and behind the scenes and stuff, how important this case is and what it represents.
Oh, 100%. This case is important for a lot of reasons, honestly. But one of the. Go ahead.
Oh no, go ahead.
I was gonna say it's case important for a lot of reasons, but one of the biggest reasons is it opened our eyes to the amount of to the deep state. It opened our eyes to what they're doing to behind the scenes. It basically peeled the curtains back to the deep state, how they operate, their propaganda. Now we know their propaganda networks and how they do things, with their influencer networks and everything. We've learned a lot, their tactics, everything. It's opened our eyes, and it's opened the public eyes too to the fact that they're all ball worshipers. That's another big thing that it's open. They're all Freemasons and Bell worshipers. The public is becoming awake and aware of that now. And it's becoming mainstream conversation now. Like, people are talking about it. That was always like a taboo topic. That was conspiracy that nobody would talk about before. Everybody's afraid to talk about it, but people are waking up. They're realizing it now, and it's becoming common knowledge. You know, only the people that were really awoke knew that that was really what's going on. But now it's gotten to the point where it's common knowledge. Like, most people now know how corrupt these people are and how evil these people are. We all feel that it's a spiritual war of good and evil. And like I said, Charlie's death was a catalyst for that. And not only was he not only a catalyst for the awakening, but he's also the catalyst for change, I think. His death is the catalyst for us all coming together.
I told you, I'm proof of that. I'm proof of that. After, you know, Charlie's death, you know, I almost did a 180 pretty much after his death.
Yeah, exactly. I see. Hold on, did you have something else you wanted to say, Billy? I see you down there. Or were you just listening?
I don't need them to come get some space so they can get in their cars, okay? Thank you.
Maybe it's a butt dial.
Yeah, she might have just butt dialed me. That's okay.
You
know what? I've done it before. It's all good.
I was going to say, we put it on live.
All right. So, yeah, I mean, that's basically all we got for today. So thank you again for coming on and joining me. I appreciate you coming on with me.
Oh, yeah. Of course. I love being here. But, yeah, you need some R&R, and so does Billy. You all need some R&R.
Oh, definitely. Yeah, these long streaming days are definitely rough, man. Especially since I'm not a streamer, man. I'm not built for this. I'm not built for these. I mean, I do long days, like doing posts and stuff, but as far as like being on camera and, you know, and talking to people all day long and stuff, that's not my thing, man. I'm not built for that. I'm not used to that. I'm not used to it. So it's definitely a lot to do that, especially for a long day stream like this, you know, for like 5 hours, 10 hours or whatever streams. It's grueling, definitely grueling.
Yeah, but and it's all perfect timing, you know. We're gonna get her done, and then Candace will come back.
Yep, absolutely. I can't wait till she comes back on, man. You know, next week when she comes back on, it's going to be explosive.
She's such a tease for people. Like, people get legitimately sad when she takes a break.
Yeah, I do too, man. I get like depressed or whatever. I'm like, oh man, no more Candace. I don't know what I'm gonna do.
One day, I was just gonna say, one day
I don't know what I'm gonna do when she takes time off for her babies, you know, to give birth and stuff. I don't know what I'm gonna do, man. I'm really gonna be depressed then. I know she'll have somebody else. She'll probably have Baron She'll probably have Baron co-host or guest host her show for her or whatever, but it's still not the same. I mean, I like Baron, but Baron's not Candace, you know?
Right. But no, she better do a live in that delivery room or something. She better do something like that.
She's like a drug, honestly. It's like watching her is like a drug. Like, you got to get your fix. If I don't get my Candace fix, you know, I get all itchy and antsy, you know?
Yeah. Look.
Yeah.
What is Tyler doing? Well, hey, we should make a meme out of that when you're waiting for Candace. Like, But
that's a good idea, actually. That's a really good idea.
We should make a meme. What was I going to say? Oh no,
sure.
one day I'm going to tell Candace, you know how they said during the Depression era when everybody was down, that they went to the movie theater and like concerts to kind of escape from reality. That's how I feel about Candace right now. Like, it's like listening to the radio in that time. It's like going to the picture show during the 20s.
Totally. I completely agree with you on that. Like, that's the only real entertainment. And it's not really even entertainment because like it's, we need that information because, we're all doing an investigation together and stuff. But at the same time, it's like, to me, it is entertainment too. Like, I feel I get that dopamine rush when she comes on and stuff, it's like, it's like relaxing. It's like, refreshing when we get to see her and stuff,
Well, and what's cool? We've gone back to the basics. Like, podcasting has replaced radio, but we're going back to like the independent journalism, bare necessities, which I think's really cool. I think it's always cool when we go back to the basics.
Oh, totally. I agree. I mean, you like I was telling you, like, the first time you came on my show or whatever, I was like, you don't have to, because I know you were like worried about having a professional microphone and all this. I'm like, you don't need that. Like, nowadays, people care about authenticity. That's what they care about. That's why this channel does so well. That's why I have a bigger live stream. Obviously today I don't, because I had to kill my live stream halfway through and start over. But for the last 2 days, my live stream has been bigger than Turning Point's live stream, has been bigger than Andrew Colbett's live stream, even bigger than Alex Jones's live stream, because like people want authenticity. They want just real people, man. They don't want polished people. They don't want people that are just toting a narrative or reading a script. They just want everyday average people, man. That's what they want. People that are telling them the truth, telling them basic common sense stuff, the same stuff that they're seeing. That's what people want.
We don't have a reason to lie.
No, exactly. There's no motive to lie.
No, but this is going to be good. I'm glad we got Billy there. I'm glad you got an insider there.
Yep, me too. Z was supposed to go as well. Was she? Absolutely. I actually had two at first. So like I said, Z was supposed to go there at first, from Unfuck America. Both of them were supposed to go there. Billy and Z were both supposed to be there. But then Z had something come up, an obligation with her Unfuck America tour thing last minute where she couldn't make it. But at least we still had Billy there, so that's cool. So not only did everybody get the commentary and us covering it, but we also have a person on the inside there, and you're getting the scoop directly from the court hearing as well. So
it's so cool. And and I'll just say one more thing. I was talking to my mom the other day, and I was telling her, like, I kind of like this whole journalism thing, like this investigative journalism thing. And, you watch television shows and movies growing up, and you see these reporters like running around and they get all excited about stories. And I told my mom, I understand the rush now of a reporter. Like when you think you have something, or you're like, oh my gosh, this fits, or you get this article. I'm like, I understand the rush now.
Oh, big time. Absolutely. Do
you remember Lois and Clark? Do you remember Lois and Clark, like the Superman? That's why, like, those types of reporters and stuff.
Totally. I get that, and that's kind of how I feel too. You definitely, it is a good feeling to know, like, if you got a big story and you see it going viral and stuff, you're like, yes, you you know, it's like a pat on the back. Like you accomplished something. It's good. It's not necessarily the views. Like I don't really care about the views, but it's like the recognition. Like all my people, my coworkers, like not really coworkers, but I guess coworkers kind of, but they're more like work colleagues or whatever. You know, when people that I also, people that I also yeah, like people that I what's it called? Not necessarily look up to, but respect. Like when I have other people that I kind of respect or whatever, they're like my colleagues, and they're patting me on the back, they're sharing my work, they like my post. It's a good feeling, when you see when I see Jesse on Fire cover my post, or Candace cover my post, or Jimmy Dore cover my post. It's a good feeling. It's like, hey, that tells you that you're doing something right. That people in it shows value, that people value what you do. They value your purpose, and that's kind of what the appreciation comes from. Not so much the views as it is, the fact that people value your work.
Yeah, and it's also, a rush to get the truth out there to the American people. Well, really the world, because the world's involved in this case. Thanks to people like Candace, and, the whole world is solving this case. So
yeah, that's what I almost thought the most.
Yeah, some of the moments that I observed today in court are just laughable, because I'm like, I think the world is like already figured this out. So for you all to be all technical and omit evidence, like it just confirms everything that we know. So
exactly,
it's funny because it's like the trial already started, discovery already started with you and Candace and Barron.
Oh, absolutely. Absolutely. Yeah. And that's kind of why, why I liked what Erica's lawyer said today, like that I was clapping. Like, I really liked what he had to say, because it was, he hit the nail dead on the head, man. The public needs to see this. If you do not show this to the public, it's going to cause distrust, in the judicial system. People are not going to trust that we're getting,
and they know
that we're getting what yeah,
they know they're on the line right now. They know they're on the line because, like I said, we've been playing discovery, and the trial already started on X very shortly after he died. So they know what they're up against, the machine that we've created.
Absolutely. And they also know that they may be protected now because Trump's in office, but that protection is not forever. That protection is going to expire as soon as Trump's out of office in 2028. The next person that gets in there might not be as sympathetic to them, especially if it's a Democrat, So, yeah, they
or
definitely,
they
so for sure, I agree with you on that.
They should be, they should be worried, and like we said, they can drag this out and run the clock out, but it's not going to change anything.
Nope.
Oh,
no, it won't. The truth will come out regardless. Yep. Patty Cakes, we appreciate you for long hours. Oh, thank you very much. We appreciate you too. Thank you for being here with us.
He's putting in overtime, y'all. OT. Well, all right, Colin.
I definitely wanted to stay after to have Billy on, because I thought that was definitely important to get that inside scoop from the courthouse.
Sure, that's our insider for sure.
Oh yeah, absolutely. But all right. Well, thank you all for joining us, and thank you once again for coming on with us today. And once again, go follow her. Make sure you're following Conservative KFC on X. Go follow her. She's done good work, and you should be a journalist too. By the way, you could do that. There's money. There's good money in it. I mean, you could very easily make a living as an independent journalist on your own without having to do any other jobs.
Well, maybe
I think
in the
it'd be
future.
a good fit for you. Definitely.
Yeah,
definitely.
maybe in the future. But we're gonna start our own firm.
Yeah, for real, absolutely. I'm down.
We should.
Also,
but yeah, no, he'll be
we
here
should.
tomorrow. You'll be here tomorrow.
Yep, absolutely. Be back here tomorrow. Make sure you come in tomorrow and watch us. Tomorrow is going to be an early stream again. We're starting early again tomorrow, so it starts at 11. Well, no, hold on. It starts. Wait a minute. It's hold on. Let me check. I forget what time it is. Let me check.
Yeah, let's see what time so people can tune in. I know. I'm getting ready to go eat.
Yeah, I've been munching on these gummy bears. You ever had these Albanese gummy bears or whatever? They're so good.
But
they're the best gummy bears I've ever had.
That reminds me of the Sean Ryan interview with Candace. Did you see that?
Exactly,
Did you see when he gave her the gummy bears? I was like, he's like, everyone gets a gift on my show. I'm like, gummy bears? I was like, is there some THC in those? That's what I was thinking. No, Candace wouldn't have eaten those.
Nah, but no, I'm definitely, I like gummy bears too, just like her. But I've never. I'll have yeah. Sean, if you're watching, send me some of your gummy bears. I'll let you know if they're good or not. But yeah, other than like I said, I'll let Sean know if his are good. But these Albanese, so far I've got to say these Albanese gummies are the best gummies I've ever tasted. And I'm not sponsored by them or anything, but they're By the way, Albanese, hit me up if you want a sponsorship deal. Hit me up. I would sponsor this because it's something I actually like. So tomorrow, yeah, I'm picky, man. I get people asking me to do sponsorships all the time, but I'm picky. I won't just put anything on my channel. Yeah, I don't just sponsor just whatever. It's got to be something I actually like and care about, or something I can actually get behind, something I use daily. I'm not just going to push something to my audience that I can't, that I don't believe in.
You're honest to a fault, Colin.
So
honest to a fault.
Absolutely. So Tyler Robinson hearing tomorrow is, like I said, it's an early one tomorrow morning, which is 9 a.m. Mountain Time, which is 11 a.m. Eastern Time. So we will be live tomorrow morning at 11 a.m. Well, actually, I will be starting like I did the last couple days. I'll be starting the stream early. Probably like 8 or 9 a.m. Eastern Time. We won't be on it yet, but I'll just be starting the live stream with a replay of like today's hearing as like a recap, getting you prepared for the new hearing. But then, so 11 o'clock is when it starts. So 11 o'clock is when we will come on live, and that's when we'll cover the new hearing. So we'll see you here at 11 o'clock tomorrow morning.
All right, I'll tune in.
Very good. And on that note, I love you all. I'll see you all later. See you on the next one.